The Senate will come to order. Senator Herpin, if you would please lead us in the Pledge of Allegiance.
Thank you, Madam President. Good morning, colleagues. Please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Majors, please take the roll.
Aguilar, Balmer, Baumgartner, Brophy, Cadman, Crowder,
Absent.
Grantham, Guzman, Harvey, Heath, Herpin, Hill, Hodge, John, Johnston, Jones, Kafalis, Kerr, King, Lambert, Lundberg, Marble, Newell, Nicholson, Renfro, Rivera, Roberts, Sheffel, Schwartz, Stedman, Doctrop, Todd, Ulibarri, Zenzinger.
Please add Senator Crowder.
Madam President,
Here. With 35 present, 0 absent, 0 excused, the Senate has a quorum. Motion to adopt the journal. Senator Zenzinger.
Thank you, Madam President. I move that the reading of the Journal of April 28th be dispensed with and the adoption of the journal as corrected by the Secretary.
For the motion, all in favor say aye. Opposed, no. Ayes have it. That motion is adopted. Committee reports.
April 28, 2014, Committee on Judiciary, after consideration of the Merits Committee recommends the following: House Bill 1296 be amended as follows and as so amended before the Committee on Appropriations with favorable recommendation. April 28, 2014, Committee on Judiciary, after consideration of the Merits Committee recommends the following: House Bill 1355 be referred favorably to Committee on Appropriations. April 28, 2014, Committee on Judiciary, after consideration of the Merits Committee recommends the following: Senate Bill 204 be postponed indefinitely.
Senate Services.
April 29th, 2014, correctly printed, Senate Bills 215, 216, 217, correctly engrossed, Senate Bill 155, Senate Joint Resolutions 30 and 35, correctly re-engrossed, Senate Bills 118, 159, 206, Senate Concurrent Resolution 2, correctly revised, House Bills 1095, 1159, 1194, 1322, and 1323, correctly re-revised, House Bills 1011, 1014, 1072, 1170, 1205, 1211, 1213, 1216, 1221, 1307, 1327, 1328, 1329, 1330, and 1331, correctly enrolled, Senate Bills 30, 49, 123, 154, and 169.
Third reading of bills, consent calendar. Mr. Majors, would you please read the titles to all of the bills on the third reading consent calendar?
House Bill 1322 by Representative McLaughlin and Senator Roberts concerning the Colorado Probate Code. House Bill 1323 by Representative Primavera and Senators Lundberg and Kafalis concerning restrictions on the ability of government entity to access an individual's personal medical information. House Bill 1159 by Representatives Young and Dorr and Senators Schwartz and Crowder concerning a state sales and use tax exemption for components used in biogas production systems. House Bill 1095 by Representative Kagan and Gardner and Senator Newell concerning the Colorado Bureau of Investigation's authority to investigate computer crime and in connection therewith making an appropriation. Senate Bill 155 by Senator Stedman and Representatives May and Duran concerning grant funding for medical marijuana health effects studies. House Bill 1194 by Representative Giroux and Senator Lambert concerning the recreation of the Legislative Digital Policy Advisory Committee.
Mr. Majority Leader.
Thank you, Madam. Boy, excuse me. Thank you, Madam President. I move the adoption of all the bills on the third reading of bills consent calendar, which includes House Bill 1322, 1323, 1159, 1095, and Senate Bill 155 and House Bill 1194.
Heard the motion. Is there any discussion on any of the bills on consent? Discussion? Are there any no votes on any of the bills on third reading consent? Senator Marble.
Thank you, Madam President. I would like to be a no on House Bill 1095, House Bill 1159, and House Bill 1194.
Okay. Senator Baumgartner.
Thank you, Madam President. I ask to be a no vote on House Bill 1159.
A no vote on which? I couldn't hear. Senator Baumgartner.
1159.
Thank you. Senator Balmer.
Thank you, Madam President. Madam President, I wish to be recorded as a no vote on House Bill 1159 and also a no vote on House Bill 1095.
Okay. Senator Lundberg.
Thank you, Madam President. Please put me down as a no on 1159.
The question is the adoption of all the bills on third reading consent calendar. With 35 ayes, 0 noes, 0 absent, and 0 excused, House Bill 1322 is adopted. Co-sponsors. With 35 ayes, 0 noes, 0 absent, and 0 excused, House Bill 1323 is adopted. Co-sponsors. Mr. Majority Leader, Madam President Pro Tem, Senators Newell, Stedman, Hodge, Herpin, Nicholson, with 31 ayes, 4 noes, 0 absent, and 0 excused, House Bill 1159 is adopted. Co-sponsors. Madam President Pro Tem, Senators Nicholson, Aguilar, Stedman, Kerr, Hodge, Newell. With 33 ayes, 2 noes, 0 absent, and 0 excused, House Bill 1095 is adopted. Co-sponsors. Senators Herpin, Lambert, King, Todd, with 35 ayes, 0 noes, 0 absent, and 0 excused, Senate Bill 155 is adopted. Co-sponsors. Senators Aguilar, Mr. Majority Leader, Madam President Pro Tem, Senators Kafalas, Nicholson, Kerr, Todd, Newell, Crowder, with 34 ayes, 1 no, 0 absent, and 0 excused, House Bill 1194 is adopted. Co-sponsors. Mr. Majority Leader.
Thank you. Gee whiz. Thank you, Madam President. Got a frog in my throat or something. Members of the moment, I'm going to move that we take up special orders to go ahead and do the second reading consent calendar of tomorrow so we can get these bills taken care of. So with that, Madam President, I move that the Senate take up Senate Bill 209 and Senate Bill 208, House Bill 1353, 1044, 1363, and House Bill 1362 on special order second reading of bills consent calendar at the hour of 9:25.
The motion is that the Senate take up tomorrow's consent calendar, specifically Senate Bills 209, 208, House Bill 1353, House Bill 1044, House Bill 1363, and House Bill 1362 on special order second reading of bills consent calendar at the hour of 9:25. This motion takes a 2/3 vote. All in favor say aye. Aye. Opposed, no. The ayes have it, and that motion is adopted. The Senate will take up those bills on special order second reading consent calendar at the hour of 9:25. The Senate will stand in a brief recess to allow the special orders calendar to be prepared and distributed. The Senate will come back to order. Special orders, second reading of bills, consent calendar. Senator Guzman.
Thank you, Madam President. I move that the Senate resolve itself into the whole for the purpose of general order, special order, second reading of bills, consent calendar.
You've heard the motion. All in favor say aye. Opposed, no. The Senate will resolve itself into a committee of the whole for purpose of considering special orders, second reading of bills, consent calendar, and Senator Guzman will take the chair.
The Senate will come to order, the committee will come to order, and the court rule is relaxed. Mr. Majors, would you please read the titles to all the bills listed on the consent calendar?
Senate Bill 209 by Senators Heath and Sheffield and Representative Tyler concerning the requirements for permissible investments by insurers and loans secured by interests in real estate. Senate Bill 208 by Senator Jones and Representative Fields concerning the reinstatement of the authority for a veteran who has not been dishonorably discharged to practice professionally. House Bill 1353 by Representative Gardner and Senator Johnston concerning powers of appointment. House Bill 1044 by Representative Dorr and Senator Tocktrop concerning consequences for a parolee who tampers with an electronic monitoring device that the parolee is required to wear as a condition of parole. House Bill 1363 by Representative Gardner and Senator Roberts concerning the non-substantive revision of statutes in the Colorado Revised Statutes as amended in connection therewith amending or repealing obsolete, imperfect, and inoperative law to preserve the legislative intent, effect, and meaning of the law. House Bill 1362 by Representative Moreno and Senator Ulibarri concerning great-grandparent visitation with great-grandchildren.
Majority Leader Heath.
Thank you, Madam Chair. I've received a request that Senate Bill 208 be removed from the consent calendar and placed on tomorrow's general order, second reading of bills. And with that, I move the adoption of all the bills listed in the special order, second reading of bills consent calendar and their associated committee reports, which include Senate Bill 209, House Bill 1353, House Bill 1044, House Bill 1363 and its Judiciary Committee report, and House Bill 1362 and its Judiciary Committee report.
Is there any discussion on any of the committee reports to any of the bills listed on the special orders consent calendar? Seeing none, the motion before the body is the adoption of all the committee reports to all the bills on special order second reading of bills consent calendar. All those in favor say aye. Those opposed say no. The ayes have it, and the committee reports are adopted. Is there any discussion on any of the bills listed on special orders consent calendar? Seeing none, the motion before the body is the adoption of all the bills on special order, second reading of bills, consent calendar. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bills are adopted. Majority Leader Heath.
Thank you, Madam Chair. I move we rise and report.
The motion before the body is to rise and report. All those in favor say aye. Aye. Opposed, no. The ayes have it, and the committee will rise and report.
The Senate will come back to order. Senator Guzman.
Thank you, Madam President. The committee has met and had a number of bills under consideration. Mr. Majors, would you please read the report?
April 29, 2014, Madam President, your committee of the whole Big City report has had under consideration the following tax bills, being second reading thereof, makes following recommendations thereon. Senate Bill 209 passed on second reading in order and gross placed on the counter for third reading and final passage. House Bills 1353, 1044, 1363 is amended, 1362 is amended, passed on second reading in order to revise, placed on the counter for third reading and final passage. Senate Bill 208 removed from the special order second reading of bills consent calendar, placed at the end of the general order second reading of bills calendar for April 30th, 2014.
Senator Guzman.
Thank you, Madam President. I move for the adoption of the report.
Any discussion? Question is the adoption of the Committee of the Whole report. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, the Committee of the Whole report is adopted. Senate Bill 209 passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. House Bill 1353, House Bill 1044, House Bill 1363 is amended, House Bill 1362 is amended, passed on second reading and order revised and placed on the calendar for third reading and final passage. Senate Bill 208 removed from special order second reading bills consent calendar, placed at the end of the general order second reading of bills calendar for April 30th, 2014. General orders, second reading of bills. Senator Guzman.
Thank you, Madam President. I move the Senate resolve itself into the Committee of the Whole for consideration of general order second reading of bills calendar.
You've heard the motion. All in favor say aye. Opposed, no. The ayes have it. The Senate will resolve itself into a Committee of the Whole for purpose of considering general order second reading of bills calendar, and Senator Guzman will take the chair.
Thank you. Thank you. The committee will come to order. The court rule is relaxed. Majority Leader Heath.
Thank you, Madam Chair, and we're going to be a little flexible today, colleagues. So right now I'm going to move that we lay over Senate Bills 177, 178, House Bill 1316, and Senate Bill 193 and place them at the end of today's calendar.
You've heard the motion. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and those bills will be laid over to the end of the calendar. Okay. Okay, so we're starting with 1269. Okay. Will that show on here? Okay, so I can just use that. All right. Mr. Majors, would you please read the title to House Bill 1269 by Senator Johnson?
House Bill 1269 by Representatives Gordon Williams and Senator Johnston, concerning the circumstances under which a person who sells items subject to sales tax must collect such sales tax on behalf of the state.
Senator Johnson.
Thank you, Madam President. I move House Bill 1269 on second reading. Ask for an aye vote.
Is there any discussion? Senator Johnson.
Thank you, Madam President. So House Bill 1269 is a modest attempt to try to take some steps on resolving the long debated and now litigated issue in the state around fair retail practices around the collection and remittance of sales taxes. You may remember House Bill 1193 from several years ago that created a structure of nexus through affiliates. This removes all of those affiliates as the proxy for nexus here in the state, and instead says that there are certain kinds of business activities like having a warehouse or having a physical presence or having existing service contracts which create the nexus. It's a small step, I think, to try to create some parity for our mom and pop and retailers here in the state of Colorado, and ask for an aye vote.
Senator Totrop.
Thank you, Madam Chair, and I have some questions about this bill. You're talking about the nexus. My concern about it is presently, and you're talking about Amazon and online shopping. Mm-hmm. And when you talk about that, my concern is, we just addressed this problem. It's in the courts, but you're saying that it's only going to tax those that have warehouses. What about Joe and Mary who buy products through Amazon who presently are not taxed? Are they going to be taxed at this time if they would buy a product through Amazon if this bill passes?
Senator Johnson.
Thank you, Madam President. So a couple things. One is that if someone has a physical presence in the state, so Amazon doesn't currently have a physical presence in the state, if there's someone that had either a physical nexus because they had a warehouse or a distribution center, or if they, for instance, there are sellers, online sellers like Barnes & Noble or Apple that do have physical locations in the state, and then they also collect and remit sales tax. So if you had the physical presence, then you would be required to collect and remit sales tax. If you don't, you don't. So it doesn't put affiliates who are the intermediate. So if Mary and Joe are people who are selling penguin hats out of their house in Thornton and are online affiliates, that does not create a nexus. But if you were someone that went to buy a book online from Barnes & Noble or online from Tattered Cover, who both have physical presence in the state, then yes, you would pay sales tax. So it just depends on whether or not that provider meets that physical requirement to the state.
Senator Totrap.
Thank you.
Any further discussion on House Bill 1269? Senator Hill.
Thank you, Madam Chair. And to the sponsor, I've got a couple of questions that have come up as well, if you're willing. I was just curious on the fiscal note side. Originally, it said this was going to cost the state up to about $68 million a year, and now it says indeterminate revenue increase. Sorry, not cost the state, be additional revenue to the state of $68 million a year, now indeterminate. Will you share with us what changed? What changed to change the fiscal note on that front?
Senator Johnson.
Thank you, Madam President. And if you look at the revised fiscal note, and I was just talking to Senator Hill, if you look at the revised fiscal note on 1269, it still specifies that same estimate on the back on page 2 of the April 7th fiscal note. It says a up to maximum amount. That's estimated from the total amount of online shopping done in total. That would require all of those providers who are now only online to create a physical presence. If that happened from those retailers, that's the total net amount. Again, there's no way to guess which one of these providers will eventually open warehouses or create service contracts in the state. That depends on what their business plans are for expansion. We don't know that, as that's just the largest possible number. It depends on independent business behavior.
Further discussion. Senator Balmer.
Thank you, Madam Chair. Well, members, this is a tax increase bill. As you know, we're not supposed to be voting on such things. The wisdom of our voters in the state, by them putting the Tabor Amendment into our Constitution, was that it would bring a check on the power of the legislature to raise taxes. And you say to yourself, I've heard this argument over and over and over again about, hey, the retailers are paying these taxes and the online companies need to be able to pay these taxes. Why don't we reverse the premise? Why don't we reverse the premise? And I do want to educate everybody on one thing. Tabor does not preclude us from cutting taxes. Oh boy, that got the room quiet. Dare say we ever cut taxes. Tabor does not preclude us from cutting taxes. So the proper solution when there is a disparity is, why don't we cut taxes on the brick and mortar to bring them in parity with the online? To say that because brick and mortar sales are taxed, therefore we should go find other innovative ways of selling products and have them be taxed too. I don't even know 5 years from now or 10 years from now how people are going to buy and sell, but I can guarantee you one thing, it won't be exactly as they do right now. We are living in an age of leapfrogging technology. People are going to be doing things in different ways in the future. And for us to try to constantly put our taxing machete in the middle of it is a wrong thing to do. The people of Colorado need less taxes, not more. And I hope that there comes a day when I'm serving in this legislature, that this legislature will be spending an hour talking about a tax cut bill. I still haven't seen one. So I encourage you, members, to not start the discussion on the premise that we have to raise taxes to equalize and make taxes fair. Let's do it the other way around. Let's lower taxes to make it fair. And I ask for a no vote on House Bill 1269.
Further discussion? Senator Hill.
Thank you, Madam Chair. Colleagues, we heard this in committee, and I'll tell you, I've got some deep concerns about it. Really, it says indeterminate revenue increase, but this is a $68 million increase in taxes on the people of Colorado. Who pays taxes in Colorado? It's the people of Colorado. It's the working families. The average income of a family of four in Colorado is $47,165. $47,165. We talk again and again and again at this microphone. We hear about the importance of protecting families, protecting the middle class, protecting those who are less able to provide for themselves. And yet here we're running this to say, nope, now we're going to charge them $68 million more dollars. $68 million more dollars to buy diapers online, $68 million more dollars to buy baby formula online, $68 million more dollars to buy household products online, $68 million to buy the things we need just to live our lives. And so I'm frustrated by the duplicity of, on one hand, saying, yes, we've got to do all we can to carve out special government programs for those who cannot provide for themselves, and at the same time, we're going to argue out of parity that we're going to charge them $68 million more in taxes. Colleagues, where's the consistency in this? Where is the sustainability in this? Yes, we're going to tax them more. Yes, we're going to have more government programs. What about just leaving this in people's pockets? I understand the argument, and I'm frustrated by the fact that we have more taxes, more regulations on Colorado businesses than we do on out-of-state businesses. But the reality is, this is what we've been saying all along. This is the problem with red tape and taxes. Red tape and taxes make it harder for businesses to keep their doors open, make it harder for them to provide the daily things that we need as working families in Colorado. And so why not acknowledge the fact that we've been unwise by putting such a high burden on our businesses here in Colorado. And rather than extending that burden, rather than saying we have to increase the pain so that everyone feels the same amount of pain, why don't we actually talk about fixing some of our mistakes? Why don't we talk about reducing the red tape? Why don't we talk about taking off some of that burden on our local retailers? And the sad truth is, as much as we say this is about equalizing the playing field, about making it easier for Main Street to compete with these online retailers, the truth is we've just taken $68 million out of the pockets of Colorado families. Well, that's $68 million they would have spent on Main Street. That's $68 million they would have spent buying goods and services here in Colorado, and now they don't have it. So not only is this a $68 million tax on the people of Colorado, but now we have $68 million less available to spend on Main Street businesses. Across the board, the economics of this don't make sense. Across the board, the success of this doesn't make sense, and I can't help but think of Milton Friedman's comments. We should analyze these policies not on their intentions, but on their results. And the fact that we're arguing for this bad policy because the result has been we've penalized business, somehow we're going to penalize business more because we've shown that penalizing business makes it harder for them to stay afloat, makes it harder for them to keep the doors open, provide the jobs, and provide the goods and services that we need here in Colorado. Colleagues, across the board, this is not the way to do it. The way to do it is to flatten, simplify, reduce the red tape we place on Colorado businesses, not expand the burden, not just to be borne by more, but to be borne by our fellow Colorado citizens. Please support me in voting against this legislation.
Majority Leader Heath.
Thank you, Madam Chair. And this is one I feel very, very passionately about. I think for those of you that were here, you know that I ran the bill in 2010 which attempted to put our businesses, local businesses, on the same footing with the companies like Amazon and others who are importing products into this state and without the benefit of having to charge a sales tax. Colorado is a small business state. There is no question about it. And sales tax is the backbone of basically providing all of the services that we enjoy, whether that's at local, county, state level. Sales tax is one of the critical elements of providing all of those services. And it seems to me that we know that small businesses are the ones that create the bulk of the jobs. 95% of the businesses in the state have less than 50 employees. This is a small business state. And the backbone of every local government is the merchant on Main Street. And keeping that merchant in business, to me, is one of the most critical things that we are tasked with doing. And when we had the advent of internet sales, it automatically placed every small business in this state at a 2.9% competitive disadvantage, which happens to be what the state sales tax is right now. Clearly, every business should be able to compete on their own merits. I've been in large businesses, I've been in small businesses, and the very essence of entrepreneurship and competitiveness in this country is being able to compete on a level playing field. Ladies and gentlemen, colleagues, we have not created a level playing field for every merchant on Main Street in this whole state. They are off the chart at a 2.9% competitive disadvantage before they even open their door. There is no way, I believe, that any of us can justify that. This bill is a small advance to at least try to get at that and let the local bookstore be able to compete. I would much rather go down and buy a book from a local bookstore than ever buy one from a company like Amazon. I'm not picking on Amazon. They just happen to be the largest internet bookseller. And they're making it very, very difficult for the Boulder bookstore to compete. Time and time again, if you walk into a bookstore, you see somebody go up and pick out a book, look at the price, and then leave, and then go back home and buy it. That is not what we should be doing for our local businesses. We absolutely must do everything we can to create a level playing field. And I would say to you, this bill is a modest step forward in that direction. So I would plead for your support of House Bill 1269.
Is there any further discussion on House Bill 1269? Seeing none, the motion division has been called or requested. Will all those in the chamber not entitled to vote please be seated? The motion before the body is the adoption of House Bill 1269. Will all those in favor please stand? Sandy, how many? Okay. 17. The bill passes. Oh, I'm sorry. God damn it.
Okay. If it's 18-year-old, you can say that. If it's not.
It is. Excuse me, members, all those not in favor of the bill, please stand. I'm sorry. I'm sorry, I made a mistake. Crucify me. Jeez.
We just went through that last month. Easter's over. Easter's over. Is this Ash Tuesday? Roll away the stone.
The bill passes. Mr. Majors, would you please read the title to House Bill 1275?
House Bill 1275 by Representatives Duran and Quorum and Senators John and Roberts concerning authorization for the Parks and Wildlife Commission to purchase real property to build a multi-use shooting facility.
Senator Roberts.
Thank you, Madam Chair. We move House Bill 1275 on second reading. And do we have any committee report?
I'm sorry, I couldn't hear. All right.
There is a committee report. I don't have.
And the Agricultural Committee report.
Yes. You have it. I don't have it.
Senator Roberts.
Thank you, Madam Chair. We move House Bill 1275 and the Agricultural Committee report.
To the committee report.
Do you want to go? Oh, okay, thank you,
Senator
Madam Chair.
Roberts, to the committee report.
Basically, what this amendment did was dealt with the issue of a July 1, 2020 deadline that was in the bill related to the purchase of land, but if this bill goes forward, we want the operations, if it's contracted out to a private party, we did not want the July 1, 2020 deadline to apply. So this removes that from any kind of contract to a private sector operator for the multi-use shooting facility. And we ask for an aye vote.
Is there any discussion on the committee report? Seeing none, the motion before the body is the adoption of the committee report. All those in favor say aye. Those opposed, no. The ayes have it, and the committee report is adopted. To the bill. Senator Roberts.
Thank you, Madam Chair. House Bill 1275 allows the Colorado Parks and Wildlife Commission to pursue the option of purchasing property near Palisade, Colorado to develop a multi-use shooting facility. This is only the authority for them to proceed. It does not actually have the money that would be allocated to do that, but it allows them to explore the option of purchasing a particular piece of property. This multi-use shooting facility also would include options for archery, and it's on the western slope outside of Grand Junction, an area that's been hit heavily hard by the recession, and it has economic development opportunities, but mostly it provides an opportunity for the public to go and have firearms instruction, improve their shooting, and also offer opportunities for youth educational, environmental education programs, and I think it's a very strong asset for the western slope.
Any discussion? Senator John, and then I'll go to Senator Trottrot.
And I will just add that the mayor of Palisade came, and he was very excited at the potential because of the economic downturn. I will also say that this again just gives us gives them the authority to pursue looking at this. It does not give them the authority to actually make the purchase. They'll have to go through the entire process, which is all of the EPA studies, all of the, they're in the prior phase right now. They would have to go through phase 1, which is current that they're doing. It's an environmental study. They will also have to go through phase 2 if necessary once they've gone through phase 1. And then, of course, the commission has to approve it. There has to be the letters from the legislators from the district, and then it would also need to go back to CDC. So it would have to go through a full process. So I would ask for an aye vote.
Senator Tatra.
Thank you, Madam Chair. And I heard this bill in committee, and I'm asking for an aye vote. We are losing a lot of areas in the state to urbanization. And I'm sure as Grand Junction starts moving east, it's possibly the same problem, losing places that people can go and practice shooting and practicing archery. And the good thing about this, it encourages young folks to get out. We need to make sure that we can get our youth out, off the couch, away from the games, and out in the environment. We need to make sure that our youth understand hunting, because the Division of Parks and Wildlife is an enterprise, and if we don't encourage hunting and fishing, and they learn that by shooting and taking hunter safety, we will not have a Parks and Wildlife, because there'll be nobody left to want to buy license to hunt and fish. And I just ask for an aye vote. This is a great bill to help the outdoors and to help youth.
Senator Roberts?
Thank you, Madam Chair. And I also wanted to mention Club 20 is in strong support of this. And as the good senator from Thornton said, we're trying to find a lot of ways to bring our youth into the world of hunting and outdoor exploration. And this would be one way to bring them in the Agricultural Committee. We have heard frequently from Parks and Wildlife the effort that's being made in Colorado to do outreach to our young folks. The average age of a Coloradan hunter is old, and we want a new generation to come forward and enjoy what many out-of-stater hunters enjoy in our state. So I'd urge an aye vote.
Senator Lambert?
Thank you, Madam Chair. I just had a question for the bill sponsors. It seems like in the national forests, there have been a lot of unilateral restrictions by the Forest Service on shooting. In some cases you can hunt, but you can't shoot. And I was wondering if the department has looked at that and, say, over the last 10 years, monitored how much of the supposedly multi-purpose land in the national forest has been declared non-multi-purpose land unilaterally by the federal government for the purposes of shooting, which is the objective of this bill.
Senator Roberts?
Thank you, Madam Chair. We did have some discussion about that in committee, and I certainly hear it at the local level in the 8 counties that I have about lack of access now. So I think there's dialogue going. I don't think this bill necessarily answers that question, but I think you raise a very good point.
Senator Lambert.
Thank you. I was wondering if you had asked or will ask the department to quantify that as how much land has been taken, basically been disallowed over the last 10 or 12 years for purposes of recreational shooting, because I don't think the state is really monitoring this type of thing for the people of Colorado.
Senator Roberts?
Thank you, Madam Chair. This bill doesn't specifically ask that question, but again, we have raised that as a concern, and actually, as the senator from Thornton said, another increasing pressure is shooting ranges that have had towns or cities grow around it, and then neighbors complain, even though neighbors came to those shooting ranges after they existed. So the pressure is multifaceted, and that's what this hopefully will provide to the people. Also, what was mentioned in committee is there is a campground close by. This is in the old Cameo power plant, that was decommissioned. So there's the idea that there will be multiple outdoor opportunities under this arrangement should Parks and Wildlife go ahead with it.
Further discussion on House Bill 1275. Senator John?
Thank you, Madam Chair, and I've been asked by the chair of the CDC Committee, the Capital Development Committee, to make sure that it goes on record that she is in support of the bill. As a final process, of course, it will be coming back through the CDC for approval. So, thank you, Madam Chair.
Senator Swartz. Oh, did you? Okay. All right. Oh, gotcha. I see. Senator Roberts.
Thank you, Madam Chair. We renew our motion for adoption of House Bill 1275 on second reading and ask for your aye vote.
So the motion before the body is the adoption of House Bill 1275. All those in favor say aye.
Aye.
Those opposed say no. The ayes have it, and the bill is passed. Mr. Majors, would you please read the title to House Bill 1359?
House Bill 1359 by Representative Janal and Senator Aguilar concerning medication synchronization for patients who are prescribed
Senator Aguilar.
medications.
Thank you, Madam Chair. I move House Bill 1359 and ask for your support.
Is there any discussion on House Bill 1359? Senator Aguilar.
Thank you, Madam Chair. This is a simple bill that will help increase adherence when patients are on a chronic regular medication regimen, and it will allow pharmacists to fill a few days' supply in patients to get a few days' supply and get early refills if they need to, if their medications are changed in the middle of the month, to allow alignment of their refill dates, and I'd ask for your support.
Any further discussion on House Bill 1359? Seeing none, the motion before the body is the adoption of House Bill 1359. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is passed. Mr. Majors, would you please read the title to Senate Bill 191?
Senate Bill 191 by Senator Toptrop concerning the procedures for resolution of workers' compensation claims.
Senator Toptrop.
Thank you, Madam Chair. I move Senate Bill 199 and the Business, Labor, and Technology Committee report. And what the committee report does, it just a technical amendment to change time from 60 to 61, and instead of saying the date of, it says the receipt of, and I ask for an aye vote on the committee report.
Senator, did you say 191?
Yes.
Or 199? Okay.
191.
Just want to verify. Is there any discussion on the Business, Labor, and Technology Committee report? Seeing none, the motion before us is the adoption of the committee report. All those in favor say aye. Those opposed, no. The ayes have it, and the committee report is adopted. Senator Toptrop to the bill.
Thank you. And this is concerning procedures for resolution of worker comp claims. This is a bill that comes forward every year where the WCEA, which is the Workers' Comp Attorney Education Association, which is a group of attorneys who represent claimants in workers' comp, and Pinnacle and the other insurers of workers' comp injuries get together and look at workers' comp issues. Pinnacle is neutral on the bill, and it just makes numerous changes to the procedures for resolving claims, authorizing the presiding officer hearing to consider the current legal medical guidelines, allows the Colorado Department of Labor to adopt rules to review and approve settlement deadline, extends the deadline for claims, allows the presiding officer to summon an out-of-state party to testify either in person or on the telephone, requires a presiding officer to issue remand orders within 30 days, permits claimants who must travel to receive a medical exam to receive funding 75 days in addition to transportation, requires that physicians who refuse to treat a workers' comp claimant must provide written notice with an explanation of to both the claimant and the employer, and increases the aggregate lump sum payment workers' compensation claimant can receive from a current limitation of $60,000 to a range between 81 and 161. Again, this bill is the work that comes about every year between the WCEA, Pinnacle, and the other insurers, and I just ask for an aye vote.
Senator Renfro.
Thank you, Madam Chair. Members, I'd ask for a no vote on this bill. Workers' comp is probably one of the biggest challenges of being in business. And yes, you want safety for your workers. You don't want them to get hurt. We do everything we can to protect our workers, to train them, to give them the equipment and the tools so that they can do their job properly and go home to their families at night. But what we're doing in this bill is we're increasing timelines, which increases costs. The longer you have a claim, the longer you have something out there, the more costly it is, and that hurts employers. I can't tell you how many times we've thought of closing our doors because of our workers' comp and our liability insurance costs. Not because of claims. We don't have claims. We're actually in the cost containment program. We're certified. We're safe. We have a injury here or there, but nothing time after time. But the costs of the insurance is out of control. And if you've talked to an employer within the last year, I bet you anything they would share with you their worries of where workers' comp insurance is going and what's going on in our state right now. It's going in the wrong direction for employers. And if we're wanting to do something that's to add growth and stability to our state, this is not it. This is going in the other direction. The second part of this, which I think is going to exponentially increase insurance premiums for employers, is the Section 9, which increases the maximum amount payable from $60,000 to $161,000. Yes, we want to take care of our workers, and I think we do when they're injured. I've seen that in my company, but what this does is it lengthens the time period and it increases the costs at a time our employers can't afford it. So I'd ask for a no vote on this bill.
Is there further discussion on Senate Bill 191? Seeing none, the motion before the body is the adoption of Senate Bill 191. All those in favor say aye. Division? A division has been called. Will all those in the chamber not entitled to vote, please be seated. The motion before the body is the adoption of Senate Bill 191. All those in favor, please stand. Members, they were asking if you would please stay where you are, quit moving around so they can count you. Please be seated. Will those who are opposed please stand? The bill passes. Mr. Majors, would you please read the title to House Bill 1180?
House Bill 1180 by Representative Becker and Senator Toptrop concerning the sunset review of the regulation of outfitters for the taking of wildlife by the Director of the Division of Professions and Occupations in connection therewith implementing the recommendations contained in the sunset report prepared by the Department of Regulatory Agencies.
Senator Toptrop.
Thank you, Madam Chair, and I move House Bill 1180. This is a sunset review bill for the regulation of outfitters, and I also move the Agricultural Committee Natural Resources Amendment.
Okay.
to
the committee report.
Yes, the committee report. What this says, there was some discussion about when the outfitters were up there about the excessive use of alcohol, and there was concern the way that the bill was written, that it would say that if a person even, anyway, we amended it that it just states that excessively or habitually uses a habit-forming drug or any controlled substance as defined in section if the use poses a risk to clients, prospective clients, or a person in proximity to activities regulated under the article. So it just states that it only would be a problem if the person is using alcohol or a controlled substance excessively while in proximity or working as an outfitter. And I ask for an aye vote on the committee report.
The motion before the body is the adoption of the Agriculture, Natural Resources, and Energy Committee report. All those in favor say aye. Those opposed, no. The ayes have it, and the committee report is adopted. To the bill, Senator Todd.
Thank you. And again, like I said, this is a sunset bill for the regulation of outfitters for hunting and fishing, and it just clarifies, put some of the clarifications in the bill that Dora recommended, and I ask for an aye vote. Outfitters are a very important part of our hunting and fishing culture. Many people come out here from out of state, and this produces a lot of really good income for the state of Colorado. But because they are from out of state or because they don't know the lay of the land, they rely on guides and outfitters to take them to where they need to go to hunt or to a really, really good lake or stream to fish. And I just ask for an aye vote on the bill.
Is there further discussion? Seeing none, the motion before the body is the adoption of House Bill 1180. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the bill is passed. Mr. Majors, would you please read the title to House Bill 1178?
House Bill 1178 by Representatives Ferrandino and Del Grosso and Senators Hodge and Grantham concerning a sales and use tax exemption for qualified property used in space flight and in connection therewith making and reducing appropriations.
Senator Hodge.
Thank you, Madam Chair. We move House Bill 1178 and the Finance Committee report.
To the Finance Committee report.
Thank you, Madam Chair. Finance Committee report, remove the sunset. I ask for an aye vote.
Is there any discussion on the Finance Committee report? Seeing none, the motion before the body is the adoption of the Finance Committee report. All those in favor say aye. Aye. Those opposed, no. The Finance Committee report is adopted. To the bill. Senator Grantham.
Thank you, Madam Chair. House Bill 1178 creates a sales and use tax exemption for qualified property that will be used in space flight, such as space vehicles, space components, equipment that will be used and placed in space vehicles, the fuel used for space flight. This bill was brought to us by the aerospace industry because they pointed out the limitations Colorado has in tax implications for the aerospace industry that doesn't exist in other competing states in this industry. What happens is when companies build this space flight property, they have chosen in the past, before this bill, to not even store this property in Colorado because it's cost prohibitive. If they actually stored the property here for more than 60 days, then they would have to take actually a title ownership of that property before they even sell the property to a private or public sector client. And then that triggers a state sales and use tax. And this is a unique problem for this industry because of the nature of the building of it and the storing of it, and then its use in other states like, well, Florida, for example, where they use this when they actually deploy into space. And this bill allows the companies that built the spaceflight property to store it in Colorado longer than those initial 60 days, since a private or public sector client may not be ready to purchase and launch the property immediately. There's also some other guardrails on here, such as requiring the Department of Revenue to provide information to the finance committees of both chambers
on the number of exemptions claimed, and we've also ensured that local jurisdictions have the ability to make the decision on whether they want to provide this exemption to the companies located in their jurisdictions. This is a good bill that removes an obstacle for our Colorado companies, an obstacle that we've created through tax policy here in this state, and it will keep those dollars here in Colorado. And I would ask for an aye vote.
Is there any discussion on House Bills 1178? Seeing none, the motion before the body is the adoption of House Bill 1178. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the bill is passed. Mr. Majors, would you please read the title to House Bill 1278?
House Bill 1278 by Representative Rosenthal, Senator Todd Trapp, concerning continuation of the Workers' Compensation Accreditation Program administered by the Division of Workers' Compensation in connection therewith implementing the recommendations of the 2013 Sunset Report by the Department of Regulatory Agencies.
Senator Todd Trapp.
Thank you, Madam Chair, and this is another sunset bill for the Workers' Comp Physician Accreditation Program. This bill is, like I said, is a sunset bill. It will continue the Workers' Comp Accreditation Program administered by the Division of Workers' Comp, and which is WCAP, and that educates physicians about the medical, administrative, and legal impacts of providing medical care to the workers' compensation system, and talks about impairment. And I just asked for an aye vote because on the sunset report.
Senator Todd Trapp, could you move your bill, please?
And I move Senate Bill 1278 and ask for an aye vote.
Thank you. Is there any discussion on House Bill 1278? Seeing none, the motion before the body is the adoption of House Bill 1278. All those in favor say aye. Those opposed, no. The ayes have it, and the bill is passed. Mr. Majors, would you please read the title to House Bill 1270?
House Bill 1270 by Representative Lepstock, Senator Todd Trapp, concerning the sunset review of the licensing of pet animal facilities in connection therewith continuing the licensing functions of the Commissioner of Agriculture and making substantive changes to the regulatory statutes.
Senator Todd Trapp.
Thank you, Madam Chair. This is another sunset bill for the licensing of pet animal facilities and continuing the licensing functions. What the bill does, it authorizes the Commissioner of Agriculture to deny, refuse, renew, or revoke a license when any controlling member of the organization has been convicted of animal cruelty or animal fighting, harmonizes the definitions of canine, hobby, and breeder facility, and dog breeder, small-scale operation, and repeals certain exemptions for non-human primates, which are apes. It also authorized the Commissioner of Agriculture to adopt rules for disclosures concerning rabies vaccination to be given by a licensee in connection with the sale, transfer, trade, or adoption of a dog, cat, ferret, or bird. I just asked for an aye bill.
Senator, would you please move your bill?
I thought I did. All right, I will move 1270 and ask for an aye vote.
All right. Is there any discussion on House Bill 1270? Seeing none, the motion before the body is the adoption of House Bill 1270. All those in favor say aye. Aye. Those opposed, no. The bill is passed. The ayes have it. Mr. Majors, could you please read the title to House Bill 1333?
House Bill 1333 by Representatives Fisher and Quorum and Senators Schwartz and Harvey, concerning the funding of Colorado Water Conservation Board projects and in connection therewith making an appropriation.
Senator Harvey.
Thank you, Madam Chair. I move House Bill 1333. Members, this is the Water Projects Bill. It's a bill that we fund every year that CWCB puts together the funding for water projects throughout the state of Colorado. I asked not to have this put on the consent calendar because I wanted to come up and talk about it. It came out of Ag unanimously and came out of Appropriations unanimously, but I wanted to talk about it specifically because some of the bulk of the funding is going for a project in my district that I've been working on since the first day I was in the legislature. The very first piece of legislation that I carried was a resolution encouraging the Army Corps of Engineers to expedite their review of the expansion of Chatfield Reservoir. And after all these years later, the Army Corps finally finished their review. We went before the Parks and Wildlife, and they've approved their review. And now we are coming back for the second major installment of funding for this project. And if you have the ability to look at your bill folder, we're putting about $90 million for loans and grants to local communities anywhere from Centennial Water District, which is Highlands Ranch Water District, all the way out to the Central Colorado Water Conservation District, which is out on the Eastern Plains, to provide renewable water, much needed renewable water along the South Platte, which will provide 20,000 acre feet of water, an additional storage capacity into the Chatfield Reservoir. This is a major project for my community. We've been working on it forever, and that is a major project that I wanted to highlight. What's that? And my very speechless, my colleague is speechless over this bill. She wanted me to remind everybody that most of this funding is going for mitigation of the expansion of Chatfield Reservoir, from the environmental impacts to increasing the or moving the marina that is currently there at Chatfield Reservoir, and the beaches and all of the impacts that will be felt by putting 20,000 acre feet of additional water into Chatfield Reservoir. Most of this $80 million or $90 million is going towards mitigation, unfortunately, rather than building projects anywhere else in the state. But that is the situation, that is the case, so I just wanted to come up here and talk about that. There are a lot of other great projects around the state. The total bill is $330 million, and there are great projects across the state. One particularly, the Long Hollow Reservoir project, that I think Senator Roberts is going to come talk about. It's an additional $1.6 million for that project. The SWAZI project is being fully funded as well for $43 million to implement the SWAZI project for increasing water throughout the Front Range. It's a great bill, great projects, and I would ask for an aye vote.
Discussion, Senator Crowder? Or Senator Crowder, and then Senator Roberts.
Thank you, Madam Chair. There was one question on this that I didn't quite understand. On the physical note, under local government impact, on the very last page, the majority of the projects funded under the bill will benefit local water districts. Is there anything in this bill that does not benefit local water districts? And if so, why would they put that in there? The majority of the funds, not all of them, but it says the majority. Can you whisper a little louder?
Senator Harvey.
Thank you, Madam Chair. Thank you, Madam Chair. Almost all of the projects do impact the local communities, but I said the SWAZI, I meant the WISE project. The WISE project is going to be to the benefit of not only local projects, but also to the state. I would argue that most of these projects, they're also beneficial to the state, and that is why we can't say specifically that it's just going to be to the local communities, but there will be state ramifications as well.
Senator Crowder.
So in your opinion, that all of this funding will benefit the state?
Senator Harvey.
Thank you, Madam Chair. I think anytime that we can provide water projects for citizens throughout the state of Colorado to help them provide much needed water capacity, that we are helping the state of Colorado, yes.
Senator Crowder.
Thank you.
You're welcome.
Senator Roberts.
Thank you, Madam Chair. And I was going to just mention the Long Hollow project that's on this list. It's 1/80th the size of the money that the Chatfield Reservoir is getting, but it is very important in satisfying our interstate compact requirements with the state of New Mexico. I do think even though Chatfield gets the large portion here, that's critically important for you on the Front Range. So one thing too I wanted to point out was many years we were taking the money to balance the budget out of this area, and so our water infrastructure is in sore need of investment, and so I think this is a good way to do that, and I do think the good senator from Highlands Ranch deserves an attaboy and maybe a beer after work. So I urge a aye vote.
Senator Brophy.
Thank you, Madam Chair. And I also ask for an aye vote on this important bill. I want to point out a little bit of history to everybody in the room, and this is important. In 1970, and I'll just have to work off my best memory here, I looked this up, but I didn't bring the numbers with me. We had about 6.5 million acre feet of storage in the state of Colorado and about 2.2 million people. Now we're looking at having about 7.5 million acre feet of storage and over 5 million people. We have more than doubled our population in the state of Colorado while increasing our water storage capacity by a mere 15%. North of 100% increase in population while only adding about 15% of additional water storage. Members and people of Colorado, we are setting ourselves up for some real challenges as a state. If you look at what's happening right now in the state of California, they are a precursor of what we may expect here in Colorado if we go into an extended period of drought, because we are mirroring their infrastructure development in the previous 40 years. Their population goes up, they don't store any more water, and they hit a drought, and now they're out of water, and it's a very, very serious situation. And that's why bills like this are so critically important. And we need to double and triple our efforts to build water storage in the state of Colorado, because if we don't, we end up drying up agriculture and drying up the economies of the rural parts of the state of Colorado, and that is a tremendous mistake. Hats off to the sponsor, Senator Harvey, for working so hard to build storage that will benefit not only his constituents, but really everybody in the state of Colorado. That is long-term thinking and real leadership, so hats off to the two of you for that. Ask that members of this body continue this effort. We need more storage in the state of Colorado.
Is there additional? Senator Harvey.
Thank you, Madam Chair, and thank you, Senator Brophy, for that. One of the other important things to talk about is how, because we've had that huge growth in population in the state over the last 20 years, we have increased our reliance on groundwater, especially in the South Metro area, where we are depleting the aquifers at the expense of future generations, because it's almost impossible to replenish those aquifers. So this bill, with regards to the WISE project, will be moving reused water throughout all of South Metro area at the same time that we are increasing the capacity of Chatfield Reservoir for renewable water. That is, we're not relying on groundwater. This is a very, very important project. These are very important projects for the long-term stability of the entire state, including the West Slope, where we won't have to go to the West Slope to look for money, or the farmers and ranchers out on the Eastern Plains. This is a great bill for all of Colorado, and I would ask for an aye vote. Thank you.
Any further discussion? The motion before the body is the adoption of House Bill 1333. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is passed. Mr. Majority Leader.
Thank you, Madam Chair. I move we take up Senate Bill 192 at this time.
The motion before the body is to take up Senate Bill 192 at this time. All those in favor say aye. Aye. Opposed, no. The motion passes, and we will take up Senate Bill 192. Mr. Majors, could you please read the title to Senate Bill 192?
Senate Bill 192 by Senator Hodge concerning the regulation of facilities license with regard to classified radioactive materials.
Senator Hodge.
Thank you, Madam Chair. I move Senate Bill 192, and I move the Appropriations Committee report.
And Senator Hodge, did you have a Health and Human Services report as well?
I do. Thank you, Madam Chair. I move the Health and Human Services report.
All right, to the Health and Human Services report.
The Health and Human Services report corrected some things that helped in noticing, as in filing notices in newspapers. It also clarified what a hearing will consist of, and it changed the word treatment to restoration to more adequately describe what we're doing.
The motion before the body is the adoption of the Health and Human Services Committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the Health and Human Services Committee report is adopted. To the Appropriations Committee report.
Thank you, Madam Chair. The Appropriations Committee report put the money in it. I ask for an aye vote.
Thank you. Is there any discussion? The motion before the body is the adoption of the Appropriations Committee report. All those in favor say aye. Those opposed, no. The ayes have it, and the Appropriations Committee report is adopted. To the bills, Senator Hodge.
Thank you, Madam Chair. Senate Bill 192 is kind of a you made the mess, you clean it up bill. It does three things. The first thing it does is it asks that 30 years after being declared a Superfund site, we still have people in Lincoln Park who do not have use of their water wells. They have been promised several times that they would get use of their water wells, but they do not have use of their water wells. They can't grow the alfalfa they had. They can't have the fruit trees they had because it's unsafe to eat those radioactive materials. So this says, hurry up and clean up the pollution going into Lincoln Park. Second thing it does is it says new technologies must be accounted for. We've got technologies being used for uranium that have never been used anywhere, ever. So we would like to put some guardrails on that say they need to be licensed in the same way as any other uranium project. And the third thing it does is it brings us into compliance with federal requirements regarding timelines for permitting. With that, I ask for an aye vote.
Is there any discussion? Senator Aguilar.
Thank you, Madam Chair. I rise in support. Members, we heard this bill in Health Committee last week, and we must have had 50 people who drove up here from Canyon City, a number of them with whom this land has been in their family for generations, and they've not been able to use the water. And it was really compelling to hear them say to us, no one is listening to us. And what we need our government for is to help us regain our rights to our land and our water. And I'd ask for your support.
Senator Crowder.
Thank you, Madam Chair. Sorry.
She'll announce there's an amendment on the desk.
There is an amendment on the desk. Mr. Majors, would you please read Amendment L006 to Senate Bill 192?
Amendment L006, Senate Bill 192 by Senator Crowder, amendment printed bill page 3, line 20.
Senator Crowder.
Thank you, Madam Chair. What we have is a very contentious situation in southern Colorado, and we're trying to straighten it out to the point where it benefits everybody involved. The prime objective that everybody wants is to clean this water up, and I concur with that issue completely. But what we need to do is we need to do this in such a way that we need to realize there's two issues here. We have milling as well as mining. And this 006, basically what that does is separate the milling from the mining, because the language here is whether above or below ground, and that's what we're trying to do. And with that said, Madam, I do believe this to be a very friendly amendment, and I've been talking to the sponsor as well as the people behind it, and I will let the sponsor talk on that in a minute, but I do believe that this is a situation where, you know, the whether above or below ground is basically that. Above ground is a milling. Now, there is some, you will hear a situation where some of the milling could be below ground, but the problem with it is anything below ground is already regulated in the mining codes of the state of Colorado. So what I do believe we can do is separate this, because I do believe if this goes forward without these two amendments, it could very well cost jobs, and that's what we're not about. But I do believe that this helps the situation considerably. I do not believe it takes any teeth out of it, and I do believe that I would ask for a yes vote and a friendly support.
Senator Crowder, could I get you to move your amendment, please?
Yes, Madam. I move 006 on 192.
Thank you. Senator Hodge.
Thank you, Madam Chair, and I'm going to ask for a no vote. Whether it's above ground or below ground, we still need the guardrails in to ensure we don't have another Cotter.
Senator Crowder.
Again, there's a separation below ground and above ground, because the milling is just primarily on top of the ground. Anything underground is already covered by the mining regulations and the safety aspects that the state has set forward, but I do ask for a yes vote.
Senator Hodge.
Thank you, Madam Chair. The brand-new procedure that we've never used anywhere ever that we're going to try in Colorado is below ground. I would like guardrails in place to protect us from another disaster.
Any further? Senator Crowder.
One final point, that the below ground is already regulated. Thank you.
Thank you. Any further discussion on the amendment? Seeing none, the motion before a division has been called. Will all those in the chamber not entitled to vote please be seated?
Well, yeah, this is just 2 minutes. What is?
Okay.
The motion before the body is the adoption of Amendment L006 of Senate Bill 192. Would those in favor please stand? Please be seated. Will those opposed please stand? The amendment passes.
This is the same one.
We are back to the bill. There is another amendment on the desk. Mr. Majors, would you please read Amendment L008?
Amendment L008 to Senate Bill 192 by Senator Crowder.
Senator Crowder.
Thank you, Madam Chair. I move L008 on Senate Bill 192. This is an additional issue that we need to take care of to make sure there's a separation between the milling and the mining. Again, this does not take the teeth out of it, because what we all want to do is clean this water mess up down there without the perception or the ability to lose jobs. And that's all this does. It separates the milling from the mining. And again, I also do believe this to be a friendly amendment to the bill. Thank you.
Senator Hodge.
Thank you. For the same reasons, I ask for a no vote on this.
Any further discussion on Amendment L008? Senator Crowder.
Just to let you know that I do consider this a very friendly amendment, and what it does is separate the milling from the mining. The mining is already under regulation, and the problem started 60 years ago without the regulation on the milling. So that's what we're trying to correct, and I do believe this to be a very good amendment that will further this bill along, and I do believe it will not only help the employment in the state of Colorado, it will also help clean this whole mess up. Thank you.
Any further discussion on Senator Jones?
I have a question for the amendment sponsor. How do you separate the milling from the mining? How do you know the difference when it's in the groundwater?
Is there any further discussion? Senator Jones.
Since I'm not getting an answer, I don't think you can separate those things. I think this is an artificial distinction. When you're addressing contamination, it's very hard to find the source, let alone if you divide the source in half. Many years ago, I actually had a role in licensing this mill, and it's mine. This is a mill, a uranium mill. And the groundwater contamination there is pretty substantial, and it hasn't been cleaned up after all these years. And the fact is if you say it's not this, but it's this, I don't see how under Superfund you can figure that out. And the liability involved with that. So I would ask for a no vote.
Senator Crowder.
Yes, thank you, Madam Chair. That's the problem with this bill. There is a distinction between milling and mining. You know, what we have down there is we have milling tailings that have been sitting in place for a number of years, which have leached into the ground. Now, that's where I would be in disagreement with the previous speaker, because there is a way to have a distinction. What we should not do is we already have the regulations in mining. What we're trying to do is we're trying to tie milling and mining together, and there's a distinct separation. I do believe had this been corrected with the last legislation 5 or 10 years ago, we wouldn't be here today. But I think the reason that we need to put this forward in this bill is to make that distinction and separate this and move forward so we can get this cleaned up. But I do believe, again, I believe this is a friendly amendment, and I would ask for an aye vote.
Senator Roberts.
Thank you, Madam Chair. And to go to the earlier question, mining and milling can be in 2 totally separate locations. So you can have out in the west end of Montrose County, you can have the mining occurring in one place and milling in a totally separate. So they are 2 different things.
Is there any further discussion on the amendment? A division has been called earlier. Will those in the chamber not entitled to vote please be seated? The motion before the body is the adoption of let me see, I lost my amendment. Here it is, I got it. Is the adoption of L008. All those in favor, please stand. Please be seated. All those opposed, please stand. The amendment passes. We are back to the bill. Senator Crowder?
With that said, Madam, I encourage everybody to have an aye vote on SB 192. It's a good, decent bill.
Senator Hodge?
Thank you, Madam Chair. I actually agree with Senator Crowder. It's a good, decent bill.
The motion, is there any other discussion? The motion before the body is the adoption of Senate Bill 192. All those in favor, please say aye. Aye. Those opposed, no. The ayes have it, and the bill is passed. Mr. Majors, could you please read the title to House Bill 1119?
House Bill 1119 by Representative McLaughlin and Senators Hodge and Roberts concerning an income tax credit for the donation of food to a hunger relief charitable organization in connection therewith reducing an appropriation.
Senator Hodge.
Thank you, Madam Chair. I move House Bill 1119, and I move do I just have an Appropriations Committee report?
Yes.
Okay, the Appropriations Committee report.
To the Appropriations Committee report. Senator Roberts.
Thank you, Madam Chair. The Appropriations Committee report just makes a little change in the title and strikes the Appropriations Clause.
Okay, any further discussion on the Appropriations Committee report? Seeing none, the motion before the body is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the Appropriations Committee report is adopted to the bill. Senator Hodge.
Thank you, Madam Chair. This is a tax credit for donating food to charitable organizations. In my neighborhood, for example, we have a bunch of farmers who do crops. They grow broccoli, they grow onions, they grow peas, that kind of thing. When they fulfill their contracts with the grocery stores and other organizations, they don't have much of an incentive to keep digging up those crops or picking those crops. This is a way to get good, fresh produce or other meats, other things, into our food banks, into our charitable food-giving organizations. It's an incentive for the farmer, and it's a good thing for the community. I ask for an aye vote.
Senator Roberts.
Thank you, Madam Chair. And in my district, it might be meat. It might be cattle, might be lamb, it might be big game. And this tax credit is a 25% tax credit for the wholesale value of the food produced and donated to food banks. It does have a cap of $5,000 per grower, and we heard from the food banks how important this would be in terms of getting fresh foods and meat to those who they try and feed, at the same time helping the rancher or farmer move their product that otherwise they wouldn't be selling. So we urge a aye vote.
Senator Brophy.
Thank you, Madam Chair. And I want to ask for an aye vote on this also. And let me tell you why it's important to have this little bit of a tax credit available for a farmer who wants to give some produce to a food bank, for instance. It costs a certain amount of money to go out and harvest this product. And this is after maybe you're already done with the bulk of your harvest, you're just gleaning the field. You'd like to find a home for the leftover watermelons, the leftover cantaloupe, the leftover broccoli, whatever it is that you don't have a contract commitment for, but it's still good enough quality to feed people. But it costs you a certain amount of money to get it out of the field, and at least this $5,000 tax credit might pay the fuel bill, for instance, and just help you to cover some of these exorbitant costs associated with harvest. Oftentimes, harvest cost is the single most expensive item associated with the production of any particular type of food. And this little bit of a tax credit will help a lot in help offsetting some of those incremental harvest costs that otherwise might leave that product in the field to rot. And that's why this is an important bill that we need to support.
Senator Ulibarri.
Thank you, Madam Chair. I want to thank the bill sponsors for bringing this forward. It's something that we heard in Finance Committee and wanted to recognize. I lifted up that generally for food donations, it's treated as a tax deduction. This is a tax credit. Why that is incredibly important is that there's a lot of effort that's gone into harvesting the crops, so there needs to be a larger ability for folks to recoup some of the costs as they take in the food from the fields or bring in meat from their ranches. And working very closely with groups like Growing Home in Westminster, fresh fruit and fresh meat is something that is incredibly rare in the food pantries for homeless families, and this is something that will really make a difference. Very strongly in support of this bill.
Any further discussion on House Bill 1119? Seeing none, the motion before the body is the adoption of House Bill 1119. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the bill is passed. Mr. Majors, could you please read the title to House Bill 1227?
House Bill 1227 by Representative Janal and Senator Nicholson concerning the sunset review of the State Board of Dental Examiners and in connection therewith continuing the board implementing the recommendations contained in the sunset report prepared by the Department of Regulatory Agencies and making an appropriation.
Senator Nicholson.
Thank you.
Madam Chair, I move House Bill 1227. There were no committee reports.
Please proceed to the bill.
Thank you, Madam Chair. The problem is that the current law did not reflect recent changes or recommendations for changes included in the Dental Sunset Report that would improve patient quality of care and patient safety. This bill, 1227, amends the Dental Practice Law of Colorado to implement recommendations contained in the Sunset Review and Report of the State Board of Dental Examiners and supported by dental hygienists and dentists.
Thank you, Senator. Is there any discussion on House Bill 1227? Seeing none, the motion before us is the adoption of 1227, House Bill 1227. All those in favor say aye. Those opposed, no. The ayes have it, and the bill is passed. Mr. Majors, could you please read the title to House Bill 1101?
House Bill 1101 by Representative Tyler and Senator Schwartz concerning a partial business personal property tax exemption for community solar gardens.
Senator Schwartz. Senator Schwartz. Senator Schwartz, you're going to be able to, do you need help? Senator Schwartz.
Thank you, Madam Chair. I move House Bill 1101. Thank you, Madam Chair. I move House Bill 1101.
Thank you. Is there any discussion on House Bill 1101? Seeing none, the motion before the body is the adoption of House Bill 1101. All those in favor say aye. Aye. Those opposed, no. Yes. The ayes have it, and the bill is passed. Okay.
Will the clerk please read the title to House Bill 1032?
House Bill 1032 by Representative Kagan and Senator Guzman concerning the provision of defense counsel to juvenile offenders and in connection therewith making and reducing appropriations.
Senator Guzman.
Thank you, Madam Chair. I move House Bill 1032 on second reading. And the, let's see, the Appropriations Committee report.
Do the Appropriations Committee report.
The Appropriations Committee, in the Appropriations Committee, let me see. I don't have my appropriations. Oh, thank you very much. In the Appropriations Committee, the bill was amended. The re-engross bill, page 18, line 7, was amended to strike $1,046,750 and substitute $698,452. There was also the substituting of or striking $169,206 and substituting $114,539, and several other strikes here. But basically, let me get over here. Yeah, that's what I have here. There was also striking $961,264 and 17.5 FTE and substituting 609,429 and moving the 17.5 FTE to 11.1 FTE. There was also the movement from 0.9 FTE to 0.6 FTE and striking $6,950 and substituting $4,865. So there were, those were the amendments taking place on the Appropriations Committee.
The motion, is there any discussion? Seeing none, the motion before the body is the adoption of the Appropriations Committee report. All those in favor say aye. Any opposed say no. The Appropriations Committee report is adopted. To the bill, Senator Guzman.
Thank you, Madam Chair. This bill basically is a bill that came out of the summer interim committee, the summer and fall interim committees. The House Bill 1032 was recommended from that interim committee that basically states that all children in custody will be represented by counsel at detention hearings, and children who receive a summons will be notified how to contact the public defender's office before their first appearance, and the public defender will appear for the first appearance if the family has applied 5 days in advance. The family has 5 days to request that service. Courts will ensure children waiving their right to counsel have the maturity to do so knowingly and voluntarily, and that the child understands they have the right to a lawyer and understands the consequences of an adjudication and sentence. So basically, that is the bill basically providing juvenile defense for our children.
Is there any discussion on House Bill 1032? Senator Harvey.
Thank you, Madam Chair. I come up and ask for a no vote on this bill. I sat in on this committee over the summer. We do have a serious problem when it comes to the juvenile justice system and juvenile prosecution. What we currently have in place is a system where the judges are rotated through the system. They are not experts on juvenile criminal law. We have district attorneys who are young, inexperienced district attorneys who are trying to get a notch on their belt and move up the ladder by proving that they're tough on crime and prosecuting juveniles to the fullest extent of the law. And we have public defenders who are also young and being thrown into the juvenile justice system without understanding juvenile justice law, all at the expense of our juveniles. And the juvenile justice system is there to try to get the kids on the right track, not to put them into an adult justice system. And what we are slowly moving toward is an adult justice system for juveniles. And I don't think that's what we want as a society. I don't think we want to have kids thrown into that system and not having a juvie system that tries to move towards rehabilitation, that tries to move towards changing their destiny, but rather throwing them into a jail, and which then puts them into that circular world of crime where they're going into prison system at a very early age. They are learning from older prisoners, older criminals, and almost incentivizing that system to grow on itself. That is not good for the kids. That is not good for the state of Colorado. And all this bill does is throw more attorneys at the system. It's not throwing more trained attorneys at the system. It's not saying that we are going to require these attorneys to be trained in juvenile justice, in the juvenile criminal code. It's not saying any of that. All we are doing with this bill is throwing more money at them and saying, here's more attorneys for you, but you're still going to be represented by people who don't understand the juvenile criminal justice system. I think that is a disservice to the kids in our system. It's a disservice to our system, and it's a disservice to the taxpayers of the state of Colorado. I wish we would just go to a full criminal justice system that is just geared towards the youth, because I think we should have judges that are just in a juvie justice system. I think we should have just district attorneys that are specialized in juvenile justice system, and I think we should have public defenders that are just focused on juvenile justice. But that's not the case. And all we are doing with this bill is throwing more money at untrained attorneys to go into the system and continue to do a disservice to the kids and to the taxpayers of the state of Colorado. So I'd ask for a no vote.
Senator Guzman.
Thank you, and thank you to the good senator who just spoke. In fact, I agree, and I think many of us who worked on this do agree. We would love to see a system that was specifically and specialized for our youth. But that is a long way off, and this is a good start. We also, this chamber also passed earlier, maybe a few weeks ago, a resolution that asked the Chief Justice of Colorado to set up a task force committee of attorneys and judges throughout Colorado to consider the issue and to consider that very question of, how do we set up a system that brings us experts, brings lawyers and others who are experts in working with juvenile defense. And we're hoping that that will, the Chief Justice has already set that committee up, and we feel that there will be some good things happening in the future. In 2012-2013, there were 9,714 juvenile cases filed, including about 4,000 of those cases for juveniles who appeared before the court for a detention hearing, and the remainder of those appeared as a result of a notice to appear or summons. But of this number, 360 juveniles were represented by a private attorney, 3,178 were represented by the Office of Public Defender, and 1,235 were represented by the Alternative Defense Council. The remaining 4,941 were not represented at any stage of the case. So almost 5,000 of those 9,700 students, juveniles, did not have any defense counsel at all. So this will put into place something immediate, something that begins to happen right away. And we think that this is about the child right now, this is about the juvenile. And though I agree with the senator that a specific system for juveniles would be even better, this is a good start, and in the meantime will help those juveniles who need immediate representation.
Is there any further discussion on House Bill 1032? Senator Marble.
Thank you, Madam Chair. And there are good things about this bill, I agree, and there are things that do not serve justice for the juveniles in our system. There is apples and oranges comparison when you look at juvenile law compared to criminal law. Are we really going to throw money at attorneys who are not going to really focus on and make it their passion in life for juveniles? If we don't, then I agree with the senator from Douglas County that yes, this is throwing money away. Is this really justice? No. This is something that we did do quite a bit, well, a lot of discussion on earlier or later in last year. There were some great points made by a judge from Weld County who I respect a great deal. She spoke to this in detail. There were many people that we heard from, including juveniles. One of the things that really struck me the most is juveniles do not get their police reports. And they have no idea about who said what, who accused them. They just go right to the DA and settle their case. No representation whatsoever. That is not justice. But then you see the DAs are not trained, most of them, in juvenile law. It's very, very different than criminal law. They have no idea what they're doing. When we throw money at something, it better be at the right thing. I wish this bill would have been discussed with more people, possibly on our side of the aisle, and looked at to see where we could make those accommodations and start things in the right direction, because this is not. A couple of things, a couple of bones we're throwing to the juvenile system, but we're really not fixing it, because the fix comes in the representation in court, which is an attorney who knows what they are doing. And criminal law and juvenile law are apples and oranges, and if you do not have the right trained attorney, then why throw money at it? It could have been just handing out and making sure that they got the police report. There's a lot that can be done with that when somebody has that. Even in criminal cases, many of the defendants do not receive a copy of that report in any supplemental, and that is what is so devastating in about many of these cases. But for this, it's a double devastation, because those juveniles are not getting proper representation by someone who is trained in juvenile law. So I have great reservations about this bill and wish that we could have discussed it quite a bit more. So I think I am a no on this bill at this time. I just wish we could use the money a little bit better, and I do agree with the Douglas County Senator that this can be a lot better.
Is there any further discussion? Senator Stedman.
Thank you, Madam Chair, and I rise in support of House Bill 1032, and I do so for a couple reasons. One, I think this is a very important issue where there's been a lot of examination of our juvenile justice system and a recognition that the right to representation is something that everyone in our state should be entitled to, regardless of whether you're in the adult criminal justice system or if you were in the juvenile justice system. And so I think this is an important step in providing the proper representation and resources to that system to make sure we have a just result. And I have to confess, I'm a little troubled by the debate we've had this morning in all of the assumptions that have been made that the lawyers that would be hired pursuant to the provisions of this act would not be competent or trained or capable of doing the task that they were hired to do. I know that the Public Defender's Office has a training budget and staff specifically for training. They currently have lawyers that specialize in juvenile justice cases. And the assumption that these people, this bill would provide the resources to hire and provide additional staffing to these cases in the juvenile justice system, that somehow those lawyers would not meet the professional and ethical standards of conduct and competency to represent clients in that arena, I think is unfounded. And I am willing to assume the contrary. And that is that the existing resources and staffing in the Public Defender's Office that provide training to their employees will ensure that these newly hired staff members are properly trained and prepared to do justice in our juvenile justice system. I think this is an important bill. An interim committee worked this summer on it, and I'm happy to support it and would encourage you to do so as well.
Thank you. Senator Cadman, Minority Leader Cadman.
Thank you, Madam Chairman. I'm not supporting this bill specifically because there is a difference in the systems for a reason. It's called a juvenile justice system. It probably should be referred to as the juvenile compassion system, because once they're in the system, the real goal of this is to make sure that these kids don't become adults in the adult juvenile justice system. So trying to, what this bill does is it starts to kind of move us backwards to a place where we actually were several years ago, many years ago, until the system was established to, frankly, reduce the recidivism of the youth at the youth level and to keep these kids from becoming part of the adult justice system. This is not an appropriate direction, I think, for us. We want to make sure that these kids have their best chance to get in and out of the system, not to become permanent members of the juvenile justice system and then to go on to become part of the adult justice system. Would ask for a no vote.
Is there any further discussion? Senator Harvey.
Thank you, Madam President. And I just want to respond to the Senator from Denver's comments about the committee that was held this summer. And I served on that committee, and I sat in on every one of the committee hearings. I understand that the senator was brought in at the very last minute because of other senators that were removed from the committee. I wish you would have been there to hear the testimony, because there was a great deal of testimony discussing how we have a significant problem with well-trained judges, prosecutors, and defenders in the juvenile justice system. That is the basis for my comments. That's the basis for my opposition to this bill. But also, my opposition to this bill is because there are a number of cases. You heard the sponsor talk about all of the individuals that were prosecuted without an attorney. That doesn't mean they were without representation. There was a lot of times when their parents were with them, and their parents said, this is what we want to do, what's in the best interest of our child, in the best interest of our family, in the best interest of resolving this situation in consultation with the prosecutor. Just because an attorney is not present does not mean that they're not, quote, represented by somebody who is looking out for their best interest. What this bill does is says that in every single one of these situations, an attorney will be brought in to represent the child, regardless of what the parents think, regardless of what the parents think is in the best interest of their child. Is that really what the direction that we want to go, is to make every one of these youth offenses becoming a criminal offense to the point where we are obfuscating the responsibility of the parents and saying we are taking the parents out of the equation and saying it has to be the decision of the attorneys, the defense attorneys, the bill that funds nothing but defense attorneys without training them? Nothing in this bill talks about training these defense attorneys in juvenile criminal justice. Nowhere in the bill does it say that. We have asked the Supreme Court to look into it, but that doesn't mean they're going to. All this says is we are going to throw a ton of money at new public defenders. Of course the public defenders are in support of that. Why would they not be? But we are taking away the parental prerogative on making the decision on what they think is in the best interest of the child and in the best interest of their family. And we're giving it to a government attorney and throwing more government attorneys into this system without being trained in how the system works. It's a terrible policy. I sat in on every one of the hearings. There is a better way of doing it, and the committee chose not to. On a partisan vote, a purely partisan vote, not one Republican in the House, not one Republican in the Senate voted for it. I would ask for a no vote.
Is there any further discussion on House Bill 1032? Seeing none, the motion before the body is the adoption of House Bill 1032. All those in favor say aye. Aye. All those opposed say no. No. The ayes have it. House Bill 1032 is adopted. Would the clerk please read the title to House Bill 1016?
House Bill 1016 by Representatives Wright and Gardner, Senators Todd and Grantham, concerning the delivery of procurement technical assistance services.
Senator Todd.
Thank you, Madam President. And with that, I move House Bill 1016 and ask for an aye vote.
Senator Grantham.
Thank you, Madam Chair. Just a quick explanation of this bill. Colleagues, this bill is the direct outworking of the task force that was created by House Bill 1301 last year and establishes the Procurement Technical Assistance Program, which the Colorado PTAC, the Procurement Technical Assistance Centers, they provide procurement technical assistance to people in the selling of products or services to the appropriate government agency by offering a confidential counseling at no cost to those businesses. The core of that assistance program is counseling and education in order to actually get through that contracting system. These PTACs are the bridge between the buyer and the supplier, bringing to bear their knowledge about the government contracting and capabilities of contractors to maximize fast, reliable service to our government, better quality and at lower costs. I would just simply ask for an aye vote.
Is there any further discussion on House Bill 1016? Seeing none, the motion before the body is the adoption of House Bill 1016. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the bill is passed. Mr. Majors, would you please read the title to House Bill 1009?
House Bill 1009 by Representative Exum and Senator Nicholson concerning changing the wildfire mitigation income tax deduction to the wildfire mitigation income tax credit in connection therewith making and reducing appropriations.
Senator Nicholson.
Thank you, Madam Chair. I move House Bill 1009, and there were no committee reports.
To the bill.
Thank you, Madam Chair. The purpose of House Bill 1009 is to reduce the fuel on private property in wildland-urban interface by providing a better incentive for property owners to do wildfire mitigation work. Beginning with income tax year 2015, this bill would eliminate the wildfire mitigation income tax deduction and create a wildfire mitigation state income tax credit. This bill originated in the Wildfire Matters Interim Committee.
Is there any discussion, any further discussion on House Bill 1009? Seeing none, the motion before the body is the adoption of House Bill 1009. All those in favor say aye. Those opposed, no. The ayes have it, and the bill is passed. Mr. Majors, would you please read the title to House Bill 1012?
House Bill 1012 by Representatives Tyler and Giroux and Senator Gonzalez concerning income tax credits that promote investment in Colorado advanced industries in connection therewith making and reducing appropriations.
Senator Gonzalez.
Thank you, Madam Chair. Good morning, colleagues. I move House Bill 1012 and the House Appropriations Committee report.
To the Appropriations Committee report.
Thank you, Madam Chair. Colleagues, the Appropriations Committee amended the appropriations clause that was placed on the bill in the House and changed the bill title, removing the reference to reducing appropriations and because we're making an appropriation. The cost of this bill is factored into the appropriations for fiscal year 15. I ask for your support of the...
There is an amendment on the desk. Mr. Majors, could you read? All right, let's go to the committee report first. Well, he just did the committee report. Yeah.
Thank you, Madam Chair. Again, I renew my request to...
Okay, for the committee report. So
the Appropriations Committee report.
Okay. All those in favor of the Appropriations Committee report's adoption, please say aye.
Aye.
Those opposed, no. The committee report is adopted. There is an amendment on the desk. Mr. Majors, would you please read Amendment L007 to House Bill 1012?
Amendment L007 to House Bill 1012 by Senator Gonzalez, amendment reading gross bill page 12, line 24, to substitute section 4 appropriation.
Senator Gonzalez.
Thank you, Madam Chair. Colleagues, Amendment L007 is a technical amendment that was recommended by the bill drafter. It simply changes the Section 4, which is the referring to the appropriations clause. It just basically changes that. It's a technical amendment to align with the other changes in the Appropriations Committee.
Thank you, Senator Kafaliis. Is there any discussion on the amendment L007? Seeing none, the motion before the body is the adoption of Amendment L007 to House Bill 1012. All those in favor say aye. Aye. Those opposed, no. The amendment passes. Senator Kafaliis, to the bill.
Thank you, Madam Chair. Colleagues, House Bill 1012 is the Advanced Industries Angel Investor Tax Credit Bill. The goal here is to encourage private sector investment and create jobs in relation to Colorado's advanced industry companies. Here we are talking about startup companies that often rely on what are referred to as angel investors in order to get through the so-called valley of death when it comes to access to capital. In this bill, House Bill 1012, we are expanding and redefining previous bills back in 2009 and 2011 that established the Colorado Innovation Investment Tax Credit, and now we are aligning it with the advanced industries. We are saying that a qualified investor can invest in a Colorado-based company and receive a tax credit of up to 25% of the investment. There's a cap. If the company is located in a rural area or an economically depressed area, economically distressed area, that tax credit can be up to 30%. And we've scaled back the appropriation. And again, the goal here is to help startup companies be successful and create incentives, address some of the risks associated with angel investment. It has a support of a lot of different business groups, and I'm happy to answer questions and engage in the discussion. Thank you.
Thank you, Senator Kafaliis. Is there any discussion? Senator Hill.
Thank you, Madam Chair. Colleagues, I heard this in Finance Committee, and I've got to say I'm really kind of depressed by the approach we're taking with this. This is a tax credit for someone who can write at least a $10,000 check. This is a tax credit for someone who has a bank account big enough that they can take big risks on startup industries. Now, I'm all about taking big risks, but you can't give a $2 million tax credit to rich investors at the same time you just voted to tax Colorado citizens with an extra $68 million when they're just trying to get a little bit cheaper diapers from Amazon.com. Colleagues, this is everything that's wrong with what we're doing up here. This is everything that's wrong with we step in and pick winners and losers. And we've already chosen for the Colorado people to be losers to the tune of $68 million. And now with this bill, we're picking for rich investors to be winners to the tune of a $2 million tax credit. Yes, I agree with the premise of this bill that when we tax things, we get less of them. That's the problem. That's why we need to reduce the taxes across the board. But to carve out a special loophole for someone who can invest $10,000 or more and take a huge risk on it is just continuing to further the income gap, to further the disparity between those who have and those who have not. If you think those who have don't quite have enough, this bill will be a good solution for you.
Senator Baumgardner.
Thank you, Madam Chair. And I had a question for the sponsor. I guess I'm not following this, and I didn't hear this in committee because this was in finance, so that's why I have some questions. So this bill is replacing the Colorado Innovative Investment Tax Credit with the Advanced Industry Investment Tax Credit. Can you tell me the difference between what these are other than just the name?
Senator Kafaliis.
Thank you, Madam Chair. When we passed House Bill 09-1105, which established the Colorado Innovation Investment Tax Credit, that was basically set up as a pilot program, operational in 2010, and we had some success in terms of helping startups and creating jobs. And so that was basically one-time funding. And since that time, we've had 1105 on the books. In 2011, we passed another bill that was looking to secure funding, and so that bill's been on the books. It's been difficult to secure the funding to be able to execute this angel investment tax credit program. So that's one difference. We are providing some funding in this particular bill, 1012, but we're also changing some of the parameters. For example, we're targeting the 7 industry sectors that are defined statutorily as advanced industries. We're also trying to create a bit of an incentive, extra incentive to invest in companies that are located in rural areas. So there one can secure up to 30% of a tax credit if you are investing in a company that's located rural. So there are a variety of changes, and for example, this bill 1012 also sets this up for 3 years. And by the way, earlier the reference was made that the cost was $2 million, and that's actually been adjusted downward, and so that's been changed. So the cost is not $2 million. The maximum per year in fiscal years 16 and 17 is $750,000, and for the fiscal year 14-15, it has a half-year fiscal impact. So the cost has been lowered. So those are some of the changes, Senator Baumgartner. I hope that helps.
Senator Baumgartner.
Thank you, and thank you, Madam Chair. Senator I'm sorry. My good friend and senator from up in the Fort Collins area, other side of Rabbit Ears, you mentioned that when this project started, it was one-time funding. Where did we get that funding from to start this? I'll start there.
Senator Kafalis.
Thank you, Madam Chair, and thank you, the good senator from the west side of Rabbit Ears Pass.
East side of Rabbit Ears.
Oh yeah, I guess technically you're right. Although I bet we both miss being up at Rabbit Ears Pass.
Today.
To answer the question, in 2010, the funding was $750,000, and that money was secured from the economic, through monies through OEDIT, the Office of Economic Development and International Trade. There were some funds that we were able to secure, actually with the help of one of the JBC members back then, but that's where the money came from, the Economic Development Commission that's kind of working with OEDIT.
Senator Baumgartner.
Thank you, Madam Chair. And although it does look like that the fiscal note has changed, but it continues to increase as the years go on. The funding continues to increase. And I guess my concern is not necessarily just this piece of legislation, but I continue to see this advanced industry technology investment in several pieces of legislation this year. So I'm trying to tie it all together to see if it's an industry or an entity that can't basically support itself and has to have money coming in from other different areas to support it. So I guess maybe that's, I don't know if it's a question, but if there's a question in there, I'd like to.
Senator Kafalis.
Thank you, Madam Chair. And respectfully, I'd like to respond. First of all, it's important to note that the House Bill 1012 does have a sunset review, so it's basically goes for 3 years. So as I mentioned earlier, the full appropriation is $750,000 per year, and then there is a rigorous evaluation of the program to determine if indeed that's been a wise investment of public sector dollars to help create access to capital in the private sector. So that I hopefully responds to the first part of your question or your comment. And regarding the second part, your point is well taken. Advanced industries are getting a lot of attention this session. I would submit that where I believe this is different is it's trying to incentivize the private sector to invest in small startup companies that are oftentimes needing that assistance to get to the venture capital stage. And if time allows, I don't know if you're, and I did put a fact sheet to this effect. In other states where they have established these angel investment tax credit programs over a longer period of time, they've proven to be quite successful in terms of attracting private sector investment in startups as well as creating jobs. I hope that helps.
Okay, thank you.
Senator Grantham.
Thank you, Madam Chair. I'll also ask for a no vote on this House Bill 1012. My colleague from Colorado Springs has already said it quite well. Folks, we are picking winners and losers here, and the winners that we are picking are those that can already write that five-figure check. Folks, that's a third of the salary of what each individual here in this chamber makes right now of an annual salary. Folks, those that are in most need are those that are left out of this process. Folks, if we want to make a difference and incentivize for investment, let's lower that threshold across the entire scope. Let's lower taxes. Let's lower the penalties that make it difficult for investors across the board in this state. Let's make it advantageous for everybody, not just the few. Folks, I would ask for a no vote on this.
Any further discussion? Senator Kapalus.
Thank you, Madam Chair. Thank you, colleagues, for the discussion. I would respectfully ask for a yes vote. I believe this is an effective tool, and what we are talking about is helping startups, getting the technology to the marketplace, helping them with access to capital when it's very difficult to get access to capital. Thank you for your attention, colleagues.
Is there any further discussion? The motion before the body is the adoption of House Bill 1012. All those in favor say aye. Aye. Those opposed, no. No. The ayes have it, and the bill is passed. Majority Leader Heath.
Thank you, Madam Chair. I move we lay over the balance of the second reading calendar until later in the day.
You've heard the motion. The balance of the second reading calendar will lay over until later in the day. Majority Leader Heath.
Thank you, Madam Chair. I move we rise and report.
The motion before the body is to rise and report. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the committee will rise and report.
The Senate will come back to order. Senator Guzman.
Thank you, Madam President. The committee has met and had a number of bills under discussion. Mr. Majors, would you please read the report?
You want to get people back here? April 29, 2014, Madam President, your committee of the whole basic report is under consideration of the following tax bills being second reading thereof makes following recommendations thereon. Senate Bill 191 is amended. Senate Bill 192 is amended, passed the second reading in order to grow space of the calendar for third reading and final passage. House Bill 1269, House Bill 1275 is amended. House Bill 1359, House Bill 1180 is amended. House Bill 1178 is amended. House Bill 1278, House Bill 1270, House Bill 1333, House Bill 1119 is amended. House Bill 1227, House Bill 1101, House Bill 1032 is amended. House Bill 1016, House Bill 1009, House Bill 1012 is amended. Pass the second reading in order to revise place of the calendar for third reading and final passage. House Bill 1294, House Bill 1350, Senate Bill 172, House Bill 1300, House Bill 1093, House Bill 1356, Senate Bill 195, House Bill 1317, Senate Bill 197, Senate Bill 203, House Bill 1175, House Bill 1326, House Bill 1310, Senate Bill 190, House Bill 1292, House Bill 1298, Senate Bill 205, Senate Bill 177, Senate Bill 178, House Bill 1316, Senate Bill 193, laid over until April 29th, 2014, retaining the place on the calendar.
Senator Guzman.
Thank you, Madam President. I move for the adoption of the report.
There is an amendment on the desk. Mr. Majors, would you please read Committee of the Whole Amendment 1 to Senate Bill 192.
Committee of the Whole Amendment 1 to Senate Bill 192. Senator Ulibarri moved to amend the report of the Committee of the Whole show the following crowd of
Senator Ulibarri. Nope.
Whose amendment?
There's nobody here to move the amendment.
I'll withdraw it.
It's been read, it has not been moved. Does anyone care to move Committee of the Whole Amendment 1? Senator Ulibarri? Committee of the Whole Amendment 1 has been withdrawn. Senator, Mr. Minority Leader.
Thank you, President Carroll. Request a roll call vote on House Bills 1009 and 1269 on the Committee of the Whole.
1009 and 1269? Did I get those numbers right? House Bill 1009 and 1269. So members, this is to single out a couple of the bills on the Committee of the Whole report. A roll call vote has been requested on how, we'll start with House Bill 1009. Mr. Majors, please poll the senators on House Bill 1009.
I know.
Aguilar.
We need him. Pass.
Balmer. Balmer, no. Baumgartner. Baumgartner, no. Brophy. Brophy, no. Cadman. Cadman, no. Crowder. Crowder, no. Grantham. Grantham, no. Guzman. Guzman, aye. Harvey. Harvey, no. Heath. Heath, aye. Herpin. Herpin, aye. Hill. Hill, no. Hodge. Hodge, aye. John. John, no. Johnston. Johnston, aye. Jones. Jones, aye. Kafalis. Kafalis, aye. Kerr. Kerr, aye. King. King, no. Lambert. Lambert, no. Lundberg. Lundberg, no. Marble. Marble, no. Newell. Newell, aye. Nicholson. Nicholson, aye. Renfro. Renfro, no. Rivera. Rivera, no. Roberts. Roberts, no. Sheffel. Sheffel, no. Schwartz. Schwartz, aye. Stedman. Stedman, aye. Talktrop. Talktrop, no. Todd. Todd, aye. Ulibarri. Ulibarri, aye. Zenzinger. Zenzinger, aye.
Auga.
So, you know, she's taking care of a sick house member. Who? Irene, that's why she's downstairs. That's why she's not here. Oh. She's performing doctors of the day. So, I don't.
It's okay, I think we have to vote anyway. They're in the change. Yeah.
Aguilar.
I read that memo, so.
Aguilar, aye. Madam President.
No.
Madam President, aye.
I appreciate that.
With 17 ayes, 18 noes, 0 absent, and 0 excused, House Bill 1009 fails. There's another amendment on the desk. Mr. Majority Leader. Mr. Majors, would you please? Okay. Before we take up the other amendment on the desk, a roll call vote was also requested on House Bill 1269. Mr. Majors, would you please poll the senators on House Bill 1269?
Aguilar. Aguilar, aye. Balmer. Balmer, no. Baumgartner. Baumgartner, no. Brophy. Brophy, no. Cadman. Cadman, no. Crowder. Crowder, no. Grantham. Grantham, no. Guzman. Guzman, aye. Harvey. Harvey, no. Heath. Heath, aye. Herpin. Herpin, no. Hill. Hill, no. Hodge. Hodge, aye. John. John, aye. Johnston. Johnston, aye. Jones. Jones, aye. Kafalis. Kafalis, aye. Kerr. Kerr, aye. King. King, no. Lambert. Lambert, no. Lundberg. Lundberg, no. Marble. Marble, no. Newell. Newell, aye. Nicholson. Nicholson, aye. Renfro. Renfro, no. Rivera. Rivera, no. Roberts. Roberts, no. Sheffel. Sheffel, no. Schwartz. Schwartz, aye. Stedman. Stedman, aye. Toktrop. Toktrop, aye. Todd. Todd, aye. Ulibarri. Ulibarri, aye. Zenzinger. Zenzinger, aye. Madam President.
Aye.
Madam President, aye.
With 18 ayes, 17 noes, 0 absent, 0 excused, House Bill 1269 is adopted. There is an amendment on the desk. Mr. Majors, would you please read Committee of the Whole Amendment 1?
Committee of the Whole Amendment 1, House Bill 1009, Senator Carroll moved to amend the report of Committee of the Whole show the House
Mr. Majority Leader.
Thank you, Madam President. I actually move, rather than Senator Carroll, to amend the report of the Committee of the Whole show that House Bill 141009 was laid over to the afternoon general orders calendar of April 29th, 2014, retaining its place on the calendar.
Mr. Minority Leader.
Members, welcome to the Senate where there's no settled questions. This is asking that a bill be laid over that we just killed, frankly, would ask for a no vote. If you voted against 1009, you should not support this motion. This is not just procedural.
This is a procedural question in the form of Committee of the Whole Amendment 1. The question is the adoption of Committee of the Whole Amendment 1. Are there no votes? Senator Cadman.
Well, I guess in that sense, all things here are procedural. That's what we do, right? But the reality of this is to undo what we just did would ask for a no vote.
Question is the adoption of Committee of the Whole Amendment 1. Are there any no votes? Mr. Minority Leader. Senators Balmer, Grantham, Harvey, Lambert.
We'll be in Senatorial 5. Oh, you're finished. Oh, I'm sorry. Sorry, I wasn't here to do it.
The Senate will come back to order. The vote question is no votes on Senate Committee of the Whole Amendment 1. No votes, Senator Cadman, Senator Harvey, Senators Shuffle, Crowder, Baumgartner, Lambert, Grantham, Herpin, Balmer, King, Brophy, Hill, Marble, Roberts, Renfro, bless you, Lundberg, Rivera. With 18 ayes, 17 noes, 0 absent, and 0 excused, Committee of the Whole Amendment 1 to House Bill 1009 is adopted. The question is the adoption of the Committee of the Whole report. Any discussion? Senator Guzman, I think you renew the motion for the adoption of the report. Senator Guzman.
Thank you, Madam President. I renew the motion to adopt the Committee of the Whole report.
Question is the adoption of the Committee of the Whole report. Are there any no votes? With 35, Senator Marble, Senator Lundberg, Senator Harvey, Senator Lambert, Senator Hill, Senator Crowder, Mr. Minority Leader, Senators Shuffle, King, Rivera, Roberts, Balmer, Renfro, Herpin, Grantham. With 21 ayes, 15 noes, 0 absent, and 0 excused, the Committee of the Whole report is adopted.
So is this one needs to get swapped out?
Just waiting on you. Senate Bill 191 is amended. Senate Bill 192 is amended, passed on second reading and ordered, engrossed, and placed on the calendar for third reading and final passage. House Bill 1269, House Bill 1275 is amended. House Bill 1359, House Bill 1180 is amended. House Bill 1178 is amended. House Bill 1278, House Bill 1270, House Bill 1333, House Bill 1119 is amended. House Bill 1227, House Bill 1101, House Bill 1032 is amended. House Bill 1016, House Bill 1012 as amended, passed on second reading and ordered, revised, and placed on the calendar for third reading and final passage. House Bills 1009, 1294, 1350, Senate Bill 172, House Bills 1300, 1093, 1356, Senate Bill 195, House Bill 1317, Senate Bill 197, Senate Bill 203, House Bill 1175, House Bill 1326, House Bill 1310, Senate Bill 190, House Bill 1292, House Bill 1298, Senate Bill 205, Senate Bill 177, 178, House Bill 1316, and Senate Bill 193 laid over until April 29th, later in the day, retaining their place on the calendar. Mr. Majority Leader.
Thank you, Madam Chair. I move that today, or Madam President, excuse me. Gosh, I haven't done that the whole session. Thank you. I move that today's consideration of resolutions calendar lay over until Monday, May 5th.
You've heard the motion. All in favor say aye.
Aye.
Opposed, no. The ayes have it. The resolutions will lay over until Monday. Mr. Majority Leader.
Thank you, Madam President. I think we will move on to consideration of House amendments to Senate bills.
Consideration of House amendments to Senate bills. Mr. Majors, would you please read the title to Senate Bill 150?
Senate Bill 150 by Senators Todd and Zenzing and Representative Hamner concerning the Colorado School Counselor Corps Grant Program and in connection therewith making an appropriation.
Senator Todd.
Thank you, Madam President. And I move Senate Bill 150 and ask for concurrence on the amendment from the House.
The motion is to concur with House amendments to Senate Bill 150. Is there any discussion? Senator Todd or Zenzinger, maybe you can explain first what the House did.
You're done. Go.
Senator Zenzinger.
Essentially, what the House did is they fixed the definition of what a first-generation college student means. That should have been done when it was in committee with us. However, we missed that.
Any discussion on the motion to concur? The question is for the Senate to concur with House amendments to Senate Bill 50. Are there any no votes? With 35 ayes, 0 noes, 0 absent, and 0 excused, the House concurs with Senate amendments to Senate Bill 50. Senator Zenzinger.
Thank you, Madam President. We move to readopt Senate Bill 150 and ask for an aye vote.
Any discussion? Question is readoption of 150. Are there any no votes? Senators Renfro, Shuffle, Baumgartner, Harvey, Lambert. Mr. Minority Leader, Senators Grantham, Marble, Lundberg, Brophy. Senator Harvey, I've got you. Senator Baumgartner, I've got you. Senator Crowder. Yeah, so not Senator Crowder? Senator Balmer. Senator Rivera. I already have you. Got you. Senator Hill. With 22 ayes, 13 noes, 0 absent, 0 excused, Senate Bill 150 is readopted. Mr. Majors, would you please read the title to Senate Bill 129?
Senate Bill 129 by Senator Stedman and Representative May concerning changes to criminal provisions related to marijuana and in connection therewith making an appropriation.
Senator Stedman.
Thank you, Madam President. I move that the Senate concur in House amendments to Senate Bill 129. Colleagues, the amendments were very minor, just clarifying that the Executive Director of CDPHE can put his or her designee in the role of certifying records, and that those records will have the watermark of the state seal within the document. And then on post-board training, they changed existing law to allow for post-boards to train drug recognition experts who will then be trainers in advanced roadside impaired driving enforcement. That's something that you'll see is being funded with marijuana tax revenues, and this is just clarifying the role of the post-board in providing that training to law enforcement officers. That's the extent of the House amendments, very minor. Same bill as we passed. I'd ask for your concurrence.
The motion is for the Senate to concur with House amendments to Senate Bill 129. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, the Senate concurs with House amendments to Senate Bill 129. Senator Stedman.
Thank you, Madam President. I move for the readoption of Senate Bill 129.
Any discussion? Question is readoption of Senate Bill 129. Are there any no votes? Senator Marble. Senator Lundberg. With 33 ayes, 2 noes, 0 absent, and 0 excused, Senate Bill 129 is readopted. Mr. Majors, would you please read the title to Senate Bill 11?
Senate Bill 11 by Senator Heath and Representative Hollinghorst concerning the Colorado Energy Research Authority.
Senator Heath.
Thank you, Madam President. I move that the Senate concur in House amendments.
Please proceed with your explanation.
Thank you. Very simply, all that was done here was to change the source of the funding.
The motion is for the Senate to concur with House amendments to Senate Bill 11. Any discussion? Any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, the Senate concurs with House amendments to Senate Bill 11. Senator Heath.
Thank you. I move for the readoption of Senate Bill 11.
Any discussion? Question is readoption of Senate Bill 11. Are there any no votes? Senators Baumgartner, Shuffle, Crowder, Lambert, Marble, Grantham, Lundberg, Balmer, Renfro, Hill, Harvey, Brophy, Rivera, Mr. Minority Leader, Senator King. With 20 ayes, 15 noes, 0 absent, 0 excused, Senate Bill 11 is readopted. Mr. Majors, would you please read the title to Senate Bill 15?
Senate Bill 15 by Senator Kerr and Representatives Young and Mountain concerning the creation of a hospitality career grant program and in connection therewith making an appropriation.
Senator Kerr.
Thank you, Madam President. I ask for concurrence on Senate Bill 15 to House amendments.
Please proceed with your explanation.
Thank you, Madam President. I move Senate Bill 15 and ask for concurrence. In the House, they simply added the appropriation and added that to the title as well.
Any discussion? Motion is for the Senate to concur with House amendments to Senate Bill 15. Are there any no votes on concurrence? With 35 ayes, 0 noes, 0 absent, 0 excused, the Senate concurs with House amendments to Senate Bill 15. Senator Kerr.
Thank you, Madam President. I ask for the readoption of Senate Bill 15.
Any discussion on readoption? Question is readoption of Senate Bill 15. Are there any no votes? Mr. Minority Leader, Senators Shuffle, Crowder, Baumgartner, Harvey, Lambert, Brophy, Lundberg, Balmer, Hill, Renfro, Marble. With 23 ayes, 12 noes, 0 absent, 0 excused, Senate Bill 15 is readopted. Additional co-sponsors. Mr. Rogers, would you please read the title to Senate Bill 64?
Senate Bill 64 by Senator Ulibarri and Representative Salazar concerning restricting the use of long-term isolated confinement for inmates with serious mental illness in connection therewith making an appropriation.
Senator Ulibarri.
Thank you, Madam President. I move that we concur with House amendments to Senate Bill 64.
Thank you. Please proceed with your explanation.
They added in and made modifications to the appropriation clause.
Any discussion? Question is for Senate to concur with House amendments to Senate Bill 64. Are there any no votes? With 35 ayes, 0 noes, 0 absent, and 0 excused, the Senate concurs with House amendments to Senate Bill 64. Senator Ulibarri.
Thank you, Madam President. I move for the readoption of Senate Bill 64.
Question is readoption of 64. Are there any no votes? With 35 ayes, 0 noes, 0 absent, and 0 excused, Senate Bill 64 is readopted. Mr. Majors, would you please read the title to Senate Bill 125?
Senate Bill 125 by Senators John and Harvey and Representatives Pabon and Zabel concerning the regulation of transportation network companies and in connection therewith requiring transportation network companies carry liability insurance, conduct background checks on transportation network company drivers, inspect transportation network company vehicles, and obtain a permit from the Public Utilities Commission and making an appropriation.
Senator John.
Thank you, Madam President. I move that the Senate concur with the House amendments to Senate Bill. I move Senate Bill 125 and move to concur with the House amendments to Senate Bill 125.
Okay, please proceed with your explanation. Senator Harvey.
Thank you, Madam President. First off, I want to thank all the members of the Senate who supported us on this bill. This is an important bill, very complicated bill, and I specifically want to thank the President for all of her hard work on this bill, because without her, we would not be where we are today. And it's a credit to her persistence that we are where we are today. First off, as you know, the bill was always very controversial with regards to the insurance issue of when the private insurance would be held in place and when the company's insurance would kick in. And there was that gray area when we left here about from when the individual driver kicked in, turned on the app, and when a rider was picked up. We weren't sure, well, I was sure, but there was some discussion of who should pick up that area. And what the House has done is said during that gray area for between now and May 5th or January 15th, the transportation network companies will have to provide the minimum insurance required in state statute, which is $25,000 for one occurrence or $50,000 for a multiple person accident. Then on January 15th of 2015, we will double that. And the coverage will have to be provided by either the driver with a rider to his private insurance or by the TNCs. And so the coverage will have to be $50,000 for an individual occurrence or $100,000 for a multiple injury occurrence. So I believe that that is much better than where we are today. I think that's better than where it was when it came out of the Transportation Committee in the House, because if you just have a minimum of $25.50 and I am the driver and I have personal insurance of $100,000, then as soon as I turn on my app, you are lowering my insurance down to $25.50, which that's making me as the driver even more liable than I would be under my own insurance policy, which I don't think is good for consumer protection or the driver's protection, because they're liable for everything else. So what was amended on the floor yesterday or Friday was that it would increase that to $100,000 or $50,000 and $100,000, which I think is appropriate for that gray area. The likelihood of anybody having an accident in that gray area that would be contested is very unlikely. But that is primary insurance. As soon as there is an accident, it's the individual TNC's coverage or the individual's rider that kicks in. They also said that there would be a study done during the interim to see if that coverage was appropriate. They also said that in addition to having a valid driver's license, proof of automobile insurance, proof of Colorado vehicle registration was added, which was probably a wise thing. Then they said within 90 days of the effective date of this part, the commission will be able to establish rules that the person is medically fit to drive. That'll be interesting to see what that means. If they have a driver's license, I think they're medically fit to drive, but okay, I'll agree to that. Then they also added a thing for the banks, because right now if you and I get in an accident and total our cars, the bank holds the title to our car so that they can be paid off. If you are a TNC driver and you get hit, that is not exactly the way it's going to work, so we put in some language to say that the driver must notify their insurance company that they are a TNC driver so that everybody understands who's going to be paid off if there is a total collision, if the car was total loss. Also, it's interesting, all of your information when you click onto the app and when you get picked up and where you go to be driven to is all kept in these TNC's databases. So pursuant to the Greg Brophy rule, we said that all of that information is private information and cannot be disclosed to anybody. They also said that a cab company or a shuttle company can roll over into a TNC if they would like to do so. They also said that all of the TNCs must display on their car that in some capacity, whether it's a pink mustache or something else, that they are a TNC driver. So that will give the PUC the ability to inspect the cars throughout the year to ensure that they are in compliance with safety concerns. The House also put in a provision that says that you cannot discriminate against riders when they are both logged in and connected to each other. If you're down in Pueblo, it doesn't mean you have to be connected and pick people up in Denver, but it does mean if you get connected via the app, you can't discriminate against somebody when you do accept that ride once you find out who that individual is. And one of the more humorous parts of the bill that I said I wouldn't say anything about, but I have to, is that they said that the driver shall immediately report to the transportation network company any refusal to transport. So it's kind of like going to confession. You have to admit that. And the Division of Labor shall promulgate rules, or may promulgate rules regarding to workers' comp. I don't believe that that will ever come into effect because these people that are the drivers are contract employees. They are not employees, so I'm not sure workers' comp will come into play. But The Division of Labor may promulgate rules if they so desire. And then there was a change in the appropriations clause, lowering it by about $50,000. And that is essentially the changes that the House did. I honestly believe that the House did very good work. Don't let them know that I said that. But I think this is a good bill the way it's coming out of here. And again, I want to thank you all for your help in getting us to where we are, especially Madam President. And Senator John particularly.
Senator John.
I just wanted to take 2 minutes to also thank President Carroll, because it was a tremendous amount of help in helping us to get some of this done. We worked very closely with the House as it went through this process, and I want to thank the sponsors in the House. They just did a fabulous job. It was a very wearing bill. It was a tough one, but at the end of the day, I am pleased with how it came out, and just again want to thank everyone that helped us and that gave us the support on this. So with that, Madam President, we move to concur with the House amendments to Senate Bill 125.
Motion is for the Senate to concur with House amendments to Senate Bill 125. Is there any discussion on the motion? Are there any no votes on the motion to concur? With 35 ayes, 0 noes, 0 absent, and 0 excused, the Senate concurs with House amendments to Senate Bill 125. Senator John.
Thank you, Madam President. We move for the readoption of Senate Bill 125.
Any discussion? Question is readoption of Senate Bill 125. Are there any no votes? Senator Crowder, Senator Hill, Senator Jones. With 32 ayes, 3 noes, 0 absent, 0 excused, Senate Bill 125 is readopted. Additional co-sponsors. Mr. Majority Leader.
Thank you, Madam President. I think you need to read.
Consent. Consideration of governor's appointments, consent calendar. Mr. Majors, would you please read the appointments to the consent calendar?
Members of the Air Quality Control Commission for terms expiring January 31st, 2017, Charles George Grobe of Cray, Colorado, serve as a person with appropriate industrial experience appointed. Anthony Gerber of Denver, Colorado, serve as a person with appropriate scientific experience appointed. Jeffrey Todd Mitchell of Aspen, Colorado, serve as a person with appropriate scientific and technical experience appointed. Member of the Colorado Traumatic Brain Injury Trust Fund Board for terms expiring June 30th, 2016, Jeffrey Paul Cuthbert, PhD, MPHMSOT of Littleton, Colorado, appointed.
Mr. Majority Leader.
Thank you, Madam President. I move for the confirmation of the appointments on the consent calendar, which includes members of the Air Quality Control Commission and a member of the Colorado Traumatic Brain Injury Trust Fund Board.
Any discussion on any of the appointments?
Lois?
Are there any no votes on any of the appointments on the consent calendar? With 35 ayes, 0 noes, 0 absent, 0 excused, Charles George Grobe, Anthony Gerber, and Jeffrey Todd Mitchell are confirmed to the Air Quality Control Commission. With 35 ayes, 0 noes, 0 absent, and 0 excused, Jeffrey Paul Cuthbert is confirmed to the Colorado Traumatic Brain Injury Trust Fund. Consideration of governor's appointments. Mr. Majors, would you please read the appointments to the Workers' Compensation Cost Containment Board?
Members of the Workers' Compensation Cost Containment Board for terms expiring December 13th, 2016, Sarah Hayes of Lafayette, Colorado, representing executives with good risk management experience in the insurance industry and as a Democrat appointed. Edward Dean Davis of Centennial, Colorado, representing employers with good risk management experience with respect to their workers' compensation insurance and as a Democrat appointed.
Senator Tucktrap.
Thank you, Madam President, and I move that Sarah Hayes of Lafayette, Colorado, and Edward Dean Davis of Centennial, Colorado, be appointed to the Workers' Compensation Cost Containment Board.
Any discussion? Question is the confirmation of those appointees to the Workers' Comp Containment Board. Are there any no votes on either of them? With 35 ayes, 0 noes, 0 absent, and 0 excused, Sarah Hayes and Edward Dean Davis are confirmed to the Workers' Compensation Cost Containment Board. Mr. Majors, would you please read the appointments to the State Board of the Great Outdoors Colorado Trust Fund?
Members of the State Board of the Great Outdoors Colorado Trust Fund For terms expiring April 15th, 2017, Natalie Jo Rogers of Yuma, Colorado, an unaffiliated member and resident of the 4th Congressional District appointed. James R. Sponsor of Lakewood, Colorado, Democratic resident of the 7th Congressional District reappointed. Alan E. Schwartz of Snowmass Village, Colorado, Democratic resident of the 3rd Congressional District and west of the Continental Divide reappointed. Peggy E. Montano of Denver, Colorado, Democratic resident of the 1st Congressional District reappointed. And Jason B. Brinkley of Aurora, Colorado, Republican and resident of the 6th Congressional District appointed.
Senator Jones.
Thank you, Madam President. I move that we confirm Natalie Jo Rogers, James R. Spanstra, Alan E. Schwartz, Peggy E. Montano, and Jason B. Brinkley to the State Board of Great Outdoors Colorado Trust Fund.
Any discussion? Question is the confirmation of those appointees to the State Board of the Great Outdoors Colorado Trust Fund. Are there any no votes on any of the appointments?
No salad in the bunch.
With 35 ayes, 0 no, 0 absent, and 0 excused, Natalie Jo Rogers, James R. Spanstra, Alan E. Schwartz, Peggy Montano, and Jason B. Brinkley are confirmed to the State Board of the Great Outdoors Colorado Trust Fund. Mr. Majors, would you please read the appointments to the Colorado Tourism Office Board of Directors?
Member of the Colorado Tourism Office Board of Directors for a term expiring June 1st, 2016, Michael Andrew Dudek of Breckenridge, Colorado, serves as a representative of private travel attractions and casinos and occasioned by the resignation of Stephen Craig Caverman of Kansas City, Colorado, appointed.
Senator Jones.
I move we confirm Michael Andrew Dudek to the Colorado Tourism Office Board of Directors.
Any discussion? Question is the confirmation. Are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, Michael Andrew Dudek is confirmed to the Colorado Tourism Office Board of Directors. Mr. Majors, would you please read the appointment to the Charter School Institute Board?
Member of the Charter School Institute Board for a term expiring July 1st, 2015, Robert Joseph LaPalme of Colorado Springs, Colorado, serves as a representative of a parent of a student who is or who has been enrolled in an Institute Charter School and as a Republican occasioned by the resignation of Donahue Cassius Quashie of Colorado Springs, Colorado, appointed.
Senator Kerr.
Thank you, Madam President. I move that Robert Joseph LaPalme be appointed as a member of the Charter School Institute Board.
Any discussion? The question is the confirmation of Robert Joseph LaPalme to the Charter School Institute Board. Are there any no votes? With 35 ayes, 0 no, 0 absent, and 0 excused, Robert Joseph LaPalme is confirmed to the Charter School Institute Board. Announcements. Oh, committee reports.
April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1001 be referred to the Committee of the Whole, favorable recommendation. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1102 be amended as follows and as so amended for the Committee of the Whole, favorable recommendation. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1124 be postponed indefinitely. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1161 be amended as follows and as so amended before the Committee of the Whole, favorable recommendation. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1173 be referred to the Committee of the Whole, favorable recommendation. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1202 be referred to the Committee of the Whole, favorable recommendation, with the recommendation be placed on the consent calendar. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1276 be referred to the Committee of the Whole, favorable recommendation. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1297 be postponed indefinitely. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1303 be referred to the Committee of the Whole, favorable recommendation, with the recommendation be placed on the consent calendar. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1338 before the Committee of the Whole, favorable recommendation, with the recommendation be placed on the consent calendar. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1283 be referred to the Committee of the Whole, favorable recommendation. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1357 be referred to the Committee of the Whole, favorable recommendation, with the recommendation be placed on the consent calendar. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1358 be referred to the Committee of the Whole, favorable recommendation, with the recommendation be placed on the consent calendar. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: House Bill 1368 be referred to the Committee of the Whole, favorable recommendation, with the recommendation be placed on the consent calendar. April 29, 2014, Committee on Appropriations. After consideration, the Mayor's Committee recommends the following: Senate Bill 180 be amended as follows and as so amended before the Committee of the Whole, favorable recommendation. April 29, 2014, Committee on Appropriations, after consideration, the Mayor's Committee recommends the following: Senate Bill 211 be amended as follows and also amended before the Committee of the Whole favorable recommendation. April 29, 2014, Committee on Appropriations, after consideration, the Mayor's Committee recommends the following: House Bill 214 be before the Committee of the Whole favorable recommendation. April 29, 2014, Committee on Appropriations, after consideration, the Mayor's Committee recommends the following: House Bill 1156 be before the Committee of the Whole favorable recommendation.
Thank you, Madam President. Colleagues, I am excited.
Now we'll go into announcements, and we'll go ahead and recognize Senator Crowder. Senator Crowder.
Thank you, Madam President. Colleagues, I am excited to announce that Live Well Colorado is ready to launch their second annual Get Moving Fitness Challenge. Last year, over 8,000 people from across the state participated in the challenge, and this year they hope to double that number. On your desk, you have a flyer with details about the challenge, which Senator Kerr is holding up, which runs from May 1 to 30. May 1 to 30, and we are all encouraged to participate in at least 30 minutes of activity each day. Thank you. Physical activity.
Senator Kerr.
Thank you, Madam President. The website, www.getmovinchallenge.com. That's getmovin, no apostrophe, no G in there. Getmovinchallenge.com has all the details, and you can sign up to track your daily activity. This new year is a competition for the title of most active city or town, so please spread the word to your constituents. This annual challenge is a fun way to engage members of the community and help us make Colorado the healthiest state in the country. Thank you.
Thank you, Madam President. Just some quick announcements before we recess. All the committees are meeting as scheduled this afternoon. Note they start at 2 p.m. Also, I've been asked to announce the Judiciary Committee tomorrow will also, in addition to the bills on the agenda already, will hear House Bills 1214, 1375, 1378, and 1379. So with that, colleagues, what I'm going to do is recess us until 4 o'clock, and we have a number of committees meeting this afternoon, and we're just estimating 4 o'clock. Finance Committee's got the larger number of bills. So pay attention. I'll come back in here if we're not ready at 4, but plan on being here at 4. So with that, Madam President, I move the Senate recess till 4 p.m. today.
You've heard the motion. All in favor say aye.
Aye.
Opposed, no. Ayes have it. The Senate will recess until 4 p.m., at which point we will all return.